Are you ready to be done? I was talking to somebody today. I was like, what is that? Not a whole lot of it.
Hold on. I'm gonna go in the hallway and announce it. And come back.
That hat needs to come off.
Move your hat, guys.
All right, it is almost 9 o'clock. All right, everyone, happy Wednesday. We are closer to Friday than we were yesterday, so everyone should be excited. And everyone should appreciate the cold weather we have. And if you don't appreciate it, then stop complaining about the heat. All right, I'm going to call the docket. And the only people who should be on the front row, oh, that's an attorney. He wasn't late, though, are people who are late. But I will note that he was on time. When I call the docket, I need you to let me know that you're here. If I don't know that you're here, I'm going to assume you're not, and a warrant may be issued for your arrest. In custody, we have David Quiones, Sergio Martinez, Luis Puente, Melissa Rich, Beverly Zuniga, Katrina Goodwin, Jesus Guitron, Brandon Richardson. Maxwell Jordan is recalled for November 17th. Aiden Silva, Cameron Sell, Corwin Campbell, Jeremy Garcia. In custody, we have Tambasi Equiri, Arthur Galindo, Melissa Carlson, Naron Alexander, Brian Parker, Tradion Johnson. Where are you? John Ayala. In custody is Sky Daniels, Jason Galfo. Custody is Kavan Rangel, Jake Gomez, David Gomez, Francisco Reyes, Logan Armstrong, Jody Ochoa. And who just walked in, you said? All right, Mr. Campbell, you need to take a seat on the first row. Talia Harris. And all right, thank you. And custody, we have Juan Garcia, David Sanchez, Kayla Rolag, Stephen Ward, Arthur Beecham, Arthur Beecham Jr. In custody, we have Victoria Cifuentes, Jose Romo. Nelda Rios is in custody. Fernando Trio. I know I'm mispronouncing that last name. There we go. I didn't add the extra syllable in. Christopher Trevino. He's on bond. Christopher Trevino. David Burnham is in custody. Christopher Ritchie, custody. Gavin Fuentes. April Keeler. Jonathan Ben is in custody. Robert Carter. In custody, we have Joe Lopez, Eric Dumba, Veronica Alvarez, and Alfredo Hernandez. Is there anyone who came in late or your name was not called? And I already have you, sir. Anyone else? All right, we will look into that.
Yes, he is here. I just.
Okay, oh, I thought I called it. Did I not call it? Okay, well, we have him on. Yes. Anyone else? Okay, all right, thank you. All right, these are the rules of the court. To my right, and probably to your left, is Criminal Trial Division. Over here is Special Crimes. Criminal Trial Division is working on a new name has more cachet or is from Law and Order. So we have Special Crimes, SVU over here, and Criminal Trial Division over here. There are boxes on either side. Just pull whatever file is related to your client and please place it on their desk, then have a seat. They will call you in the order of appearance. So whoever puts their file down first, that's who's going to get called first. Do not approach the court unless you confer with the state. If the state has given you an offer, you need to have given that offer to your client. Then you can approach the clerk, ask them to put the file up next to me, have a seat. Again, I will call you in order of appearance. Do not approach the court if you have a client in custody and they have not been brought out. If you ask the deputy to have your client brought out, do not leave the courtroom because they have a lot of inmates to bring out. If your client needs an interpreter and you request an interpreter, do not leave because that interpreter is going to come right away and they're shorthanded with interpreters. And if you leave, that interpreter is going to leave. So today is Wednesday. It's a beautiful day. We're in the middle of the week. Put some patience in your pocket. We will get through this docket as quickly as possible, all the while seeing that everyone's due process rights are honored. All right, everyone, please confer kindly. All right, thank you.
Oh, I know. You should be all here.
Oh. Always.
All right, could I see Gavin Fuentes? Yes. So do you understand why you're here today?
Yes, ma'am.
Why?
Because of the rights of the UAs, and I believe I had my lawyer too.
No, it's not. It is, one of the issues is your UA.
And the patient.
Yeah, you're not doing it. So why are you not doing that?
I've been dealing with a lot of stuff, and I have 2 babies at home, 2 newborns, not newborns, but an 18-month and a 2-month-year-old. And I've just been dealing with a lot of stress. My 18-month-year-old is like showing signs of autism, so I have to be doing therapy treatments, and I've been doing that. I've just been dealing with a lot of stress lately.
All right, so here's your issue. Number one, you're not supposed to be having contact with Alexis Zuniga,
Yes, ma'am.
and you are having contact with her.
No, ma'am, there was a motion to drop it down, I believe. And my probation officer knows that, and my lawyer knows that as well.
Well, there was a motion, but did I rule on that motion that you could have contact?
No,
Have I
ma'am,
ruled on that motion?
but I haven't.
So why do you think that just following a motion means that permission has been granted? Let me explain to you something. A lot of people say it is better to ask for forgiveness than permission. When you're on probation, it is better to ask for permission than forgiveness, because what that means is you're not following the rules I've set for you. You are on deferred adjudication for assault, family choking, strangulation. That's a 3rd-degree felony. The range of punishment is up to 10 years in prison. And I don't know what you don't understand when I say that you are not to have any contact with the complainant in this case. I don't care what she's asking for. I don't care what you are asking for. When I say no contact, I mean no contact. So what do you not understand?
I understand completely, ma'am. I only been speaking through it with her mom and through siblings, like her brothers.
No contact.
Yes.
And you have admitted to having contact with her. And I told you you're not to have any contact with her. So we have an issue with that. We have an issue with you with not doing your UAs. We have an issue with you with not doing NPs because you won't do your UA. So explain to me why you are not doing your UAs.
It's just I've been dealing with a lot, like I said, and I have 2 kids at home, and not at home, or I just support them a lot, and I always like Cash App, or I do bank transfers. I just try to do my best to support the kids, and I've been working nonstop. I worked for Art and Deja. It wasn't until like 2 weeks ago. I got a new job at McKinney's fencing, and I've been trying to I just wanted to get a new job and a better job, and that job opportunity came up. So
Well, do you want to get a job at the prison? I don't know if they still let people make license plates at the prison, but that will take away your stress and everything. If you're at the prison, is that what you want?
Oh, no.
So the problem is you're on deferred adjudication for assault, family choking, strangulation. And part of the issues that may have gotten you here or contributed to it is your drug use. And guess what? I put you in intensive outpatient treatment instead of inpatient treatment, and you won't do UAs. So to me, if you can do the classes, you can do the UA. And you've been tested positive. So when you get UA today, which you will, what are your results going to be?
I'm going to be low levels for THC or nothing.
No, don't do me low levels. What are your results going to be?
Positive for THC.
And why are you using marijuana and you're not supposed to?
Like I said, I just have a lot of stress lately, and been working nonstop, and all my money just been going to my 2 kids that I've been supporting.
You mean your children?
Yes, ma'am.
Well, here's the thing. You have children, you got to support children, but you also have to follow the rules. And you would not be here if you had not committed an assault, family choking, strangulation. So I don't know what you don't understand. Would you like to go to prison to have a chance to think about your life and where it's headed? Then you had better start doing what the court is telling you to do. This is the absolute last time we are going to have a compliance hearing.
Yes, ma'am.
Do you understand?
Yes, ma'am. Overstood.
You are doing intensive outpatient treatment. You are starting it over. If you miss 1 UA, we're not having a compliance hearing. Probation is going to file a motion to revoke. I'm going to review it. And if it's in proper order and it looks like a violation has occurred, I'm going to sign it. Wherever you may be, you're going to be picked up by the police because there's going to be a warrant out for your arrest. We will hear your case either while you're at the Bear County Jail, you'll be brought over, we will hear it, or either you will make a bond and you will be on bond and we'll hear your case. And then if it is proven to be true, and I find it true, then you're looking at potentially going to prison for 10 years.
Yes, ma'am.
So do we have any other issues that you don't understand?
Ma'am, it's understood.
And as far as the pressures you're under as to make the mortgage payment, the rent payment, deal with children. And how old are you?
21, remember?
All right, you're a 21-year-old, you made the decision to have children, not figuring out how to financially support them. And I don't know why people do that. People just willy-nilly decide to have a bunch of children. They don't think about, how much is daycare going to cost? Who's going to be paying for the children's clothes? Who's going to pay for their formula? And I know I have a niece, formula is expensive. And that's something people never think about. But you're in a situation where you're just going to have to deal with it. If you wouldn't have committed this assault, family choking, strangulation, you wouldn't be on deferred for it. And you would have been able to work 2, 3 jobs, how many jobs you need to work to support your 2 children. But you did. So that's why you're here. And you have a contract with me and you had better follow through on it. Do you understand?
Yes, ma'am. Understood.
So we're going to do a UA today. I'm going to want him tested for levels. If his levels rise, a motion to revoke, I want it filed. If he missed reporting, I want a motion to revoke file. If he misses classes with intensive outpatient treatment, I want a motion to revoke file. If he misses a UA, I want a motion to revoke file. Do you understand? And if there are issues where you have stressors and you need to talk to someone, probation can set that up for you. And part of your stressors could probably be addressed in intensive outpatient treatment, but you won't give them a chance. Do you have any questions?
No,
Is there anything you need from the court to be successful on this probation?
no, ma'am. I don't know what needs to be done.
And where are you staying? Who with?
I'm staying with my mom.
Is he supposed to have contact with his mom?
I believe we dropped it to a non-harmful.
I know he has no contact with his father.
Yes, Your Honor, and with regards to his father reached out to probation asking that the order be reduced to no harmful endurance contacts. As far as his mother is concerned, let me look at the notes real quick.
Okay, and I think I'm looking at my docket sheet. It says no harmful or injurious contact with Olga Soto.
Okay.
Yeah, I'm going to keep the no contact with your father. And let me just, with Michael Fuentes, and let me just tell you why I'm doing that so you can understand where I'm coming from. I'm doing that because your father, I know the only reason why he wants the no contact order lifted with him is because of your mom. But you behave very badly with him. That's why there's a no contact order in place. So you get your life together, he comes in and I speak with him and address certain things, then I may consider lifting it. But for now, there's still going to be no contact with the father. Contact or no harmful or injurious contact is going to depend on your actions. And whether or not I change my mind about you having contact with Alexis is going to depend on your actions. But if you continue on the path that you're on, you're looking at a motion to revoke and potentially 10 years in prison. You understand? So from here on out, every decision you make and everything you do, you need to ask yourself one question. Is this something that could result in me going to prison for 10 years? And if you are unsure whether or not it will result in you going to prison for 10 years, you probably shouldn't do it. You understand? All right. Do you have any questions about anything?
Your Honor, can I send him to the lab so that we can get the levels?
Yes. So you're going to be tested for levels today. You understand? Okay. All right. Probation will speak to you. Just have a seat on this side of the room. Who's here on Talia Harris? And where is Miss Harris? Oh, I'm sorry. Mr. Harris, come forward. Let me see what page they are on. Do you see which page Harris is on? All right, thank you. All right, so what is happening with this case? Where are we? State?
Your Honor, the state has made a plea bargain offer and my client has rejected that.
Okay. And was that offer made today?
It was made prior.
All right. Do you have all the discovery?
I do, Judge.
All right, so I need an acknowledgement of discovery done today. And Mr. Harris, I'm going to give you a plea deadline date. In this court, I give everyone a plea deadline date. And of course, if you decide not to accept the offer, then what will end up happening is that the court will not consider any plea bargain offers unless there's good cause. Otherwise, if you decide to plea, you have to plea open to the court. Do you understand? Okay, so let me see where I'm going to put you.
I do have an additional request after the scheduling.
Oh, yes,
Originally, I filed a motion to have the monitor removed.
yes.
Court, that ordered tracking that.
So what I will do is we will set this for your plea deadline date for December 14th. And then we can have a hearing on your bond matter. And I will give you a reset form. And have you already filed that bond?
I did, I filed it about, I guess, 2 months ago, 3 months ago.
All right, for some reason, it's not in the file. Sometimes it doesn't make it to the file.
If they got rejected or anything, I can refile it.
Oh, just make sure when you have it set, if you'll be kind enough to bring in an extra copy.
Okay.
Let me see. Today is the 16th.
Oh, this is a full service spot.
Yes. Oh, no problem. Here you are.
So once Mr. Harris signs, we're free to go?
Yes. Oh, oh,
Okay.
yeah, because I think on some of the last page say something. Yes.
Thank you.
All right, David Gomez. Yes.
He's in the box.
All right, state on David Gomez. This is one where you all were going to speak to the complainant.
Yes, Judge, I made an offer.
I relayed the offer. The offer was rejected.
All right, Mr. Gomez, if you come forward, please. All right, Mr. Gomez, do you have, if everyone could please make sure you whisper. Counsel, have you received all the discovery?
I had an opportunity to view it. Yes, I have.
All right, state, I need an acknowledgement of discovery.
Yes.
And when was the offer tendered?
Right now.
Okay. All right, Mr. Gomez, I'm going to set your plea deadline date on this case for December 1st. And at that time, you need to let the court know whether or not you're accepting the state's offer. If you choose not to accept the state's offer at that time, then the court will not accept any plea bargain agreements unless it's open to the court or without good cause. You understand?
Your Honor, I returned to the continent on December 4th.
Oh, okay, we'll not do that date then. Is December 9th okay?
Yes, Your Honor.
Hey, where are you headed?
Greece, Egypt, Qatar.
Okay, you're gonna have to let me know how Egypt is. I'm interested in going.
Your Honor, you get in the postcard.
All right, thank you so much.
Or your mother will, not you.
Okay, awesome.
Thank you, Your Honor.
Hey, before you leave, just 1 second. And Mr. Gomez, we'll see you back on that date then, okay? December 9th.
Appreciate it.
All right.
All right.
Yes.
She loves to get that. She still has the, what you got her from South Africa.
Oh, wow. I meant that was a long time ago.
Yes.
That was the last World Cup I went to. Who knows what I'm gonna find in Egypt?
Yeah.
I'm gonna send me the courthouse general. Take care, Your Honor. See you then.
All right, thank you. Have a
Thank
good
you.
one.
Yes, Gavin Fuentes.
I'm still here. There's an issue I want to discuss with you regarding the two new contracts.
Mhm.
I don't know if you want to do it now or file a motion.
Yes,
You want to file a motion?
yes, because I've already addressed the no contact with him.
All
right.
I'll do that and he's otherwise.
Yes.
Bring the intake. You have an exhibit. Thank you. What do you different?
Yes, sir. There you
Who's here for, hi,
How are you, Your Honor?
great, good seeing you,
Good to see you.
and good seeing you.
Poor guy.
All right, who is here for Rodney Sanders? Mr. Sanders, who's your attorney?
Cody Ochoa. Mr. Longacre.
All right, just give us a moment. I'm gonna put you in the waiting room. Your attorney's not here yet, okay?
Judge, did you get an invite to our
No, I did not. Thank you very much.
Thank you. Hope you can make it.
I'm gonna do my best.
Hopefully the weather will be.
Well, hey, if the temperature is cool, that will be a great thing. Who's here on Ron Alexander? Good morning.
Are we approach?
Yes. All right, so, oh, it's behind. So let me just find him on the docket. All right, so where are we on this case?
Your Honor, we believe it's gonna be a plea. There's a substantial amount of restitution, and we would like to see if we can't gather some more funds to put him in a better place for when that time arrives for a plea. Bottom line is we'd like to continue.
Okay, so how much time are you asking for?
Well, I would
It's-
like to point out that this case is Nicole Thornborough's case, and she's out on medical leave, and she's got about a 6-week recovery period.
Okay,
So if we could take that in consideration on a second.
so when are you thinking she is going to be back?
Probably sometime in January. And then I don't know what it is that the defense will need.
That sounds fine to us.
All right.
She's gonna be healed up by.
All right, so I'm gonna give you a plea deadline date, and after this date I give you, that's it. I'm gonna give you a plea deadline date in February. And whatever you all are working on, it needs to be done by that time.
Fair enough, Judge.
All right, so I'm gonna put you down for February 24th. That doesn't sound like a holiday. Is February 24th a holiday? Anyone?
Is that Valentine's Day? Oh.
All right, so on this
Romantic
one,
guy,
we're gonna set it, plea deadline date. It's on Naron Alexander for February 24th. Okay, here you are. So what that means is on February 24th, that is your final day to enter a plea. If you choose not to enter a plea, the court will not accept any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. You understand? All right, is there anything else?
No, thank you, Your Honor.
All right, you're welcome. Just get a reset form from the clerk and you are excused. Thank you.
I'm CK.
Arthur Beecham. Good morning. All right, so what is happening with this case?
Your Honor, we're still pending the results of the competency evaluation, but we're here today on a motion to modify the bond.
Aware that the evaluation was still pending. I thought it was my understanding that we couldn't do anything if there's a competency evaluation.
No, I mean, you can't do anything as far as the actual case, but the conditions, you can do
Okay.
some things. So is there any, why is the request for tracking?
Your Honor, and I do have one witness who's on to testify. He's been on full house arrest for 90 days, Judge. My client's has several mental health diagnoses. He's working in conjunction with True Mental Health. I do have an exhibit there from his case managers. He's been on the shot, which is significantly improving his symptoms. We continuously have to ask for permission from pretrial for him to go to his appointment, Judge.
So can I just order that he be allowed to go to all medical appointments and they do it?
Well, Judge, that's part of it, Judge, but it is really, being at the house all the time is really affecting my client's stress levels, Judge. And so partly why I filed this motion is to see if we allow him just a little more leniency due to the fact that he's been compliant for 90 days.
Where does he want to go?
Well, Judge, he helps take care of his little sister. They go on walks, occasionally to the grocery store with his parents, things like that. Anywhere that my client goes, he's gonna have to be transported by family. His grandmother, she was an RN, but she is retired, so there's someone with him at all times, Judge. And just due to the fact that he's been compliant for this long and was also in custody for over 5 months, we're asking for a little leniency from the court.
Have you conferred with the state over the bond issue?
I have, Judge.
State, are you in agreement to him being allowed tracking as long as he's with an adult?
No, Judge, we were in agreement for partial to go to appointments and work.
Okay. All right, court is going to call 2020 CR 5669, State of Texas versus Arthur Beecham. Could I have parties approach and announce for the record for the state?
Marcus Sanders.
Defense?
Christine McDonald, Judge, and it's I'm so sorry, Judge, it's 2022 CR.
Oh, okay, I guess I said the wrong number. 2022 CR 5669. All right, defense has filed a motion to modify the defendant's conditions of bond. State, have you had a chance to review the defendant's motion?
Yes, Your Honor.
All right, are you opposed?
We are, Judge.
All right, defense, you may proceed. Do you have any witnesses?
Thank you, Your Honor. At this time, I'd like to call my client's mom, Stephanie Good.
All right, and Mr. Beecham, if you'll just move to the side. Can you raise your, good morning. Can you raise your hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you speak up so that the court reporter can hear and so that I can hear.
Yes, ma'am.
All right, state your name for the record.
Stephanie Nicole Good. Stephanie Nicole Good.
All right, are you able to hear that? All right, defense, yes.
Ms. Good, how are you currently employed?
Pediatric nurse through ABC Healthcare.
I'm sorry,
ma'am,
I need you to speak up.
Okay, pediatric nurse through ABC Healthcare.
And this is your son, Mr. Beecham.
Yes,
correct?
ma'am.
And is he currently living with you?
Yes, ma'am.
Who else lives in the home?
My mother.
And what's your mother's name?
My mother's Irene Hall.
And she's retired right now?
Yes, ma'am. Retired registered nurse.
So she's familiar with my client's diagnosis and how to help care.
Yes, ma'am.
Okay. Is she at the house at all times while Arthur is
ma'am.
there? We need to go one at a time because the court reporter is taking the record.
Okay.
Okay, so just bear with me, okay? So can you tell me, what is my client diagnosed with?
Arthur has epilepsy from birth, mood disorder, chemical imbalance, asthma, heart issues, schizophrenia. Whole 9 yards of mental health.
Okay, and can you tell me, what medications is he currently on?
Right now, he takes the Abilify shot once a month on the 15th. He also takes Wellbutrin and he also takes Zoloft.
When did he start using the long-lasting injection?
He's been on the long-lasting injection since he was 8 years old.
And how did you get connected with True Mental Health Services?
Through referral from the mental health foundation downtown.
Okay, and is this the first time he's ever been enrolled through them?
Oh, no, ma'am.
No, okay.
No, ma'am.
So can you tell me what do those services look like? How often do these case managers come in contact with them?
The case managers are coming out, right now, their visits are 2 times a week. And he also sees the nurse practitioner every 2 weeks.
Okay, and if there's ever like maybe negative symptoms or outbursts or anything that may or may not go on, how quickly can he get in to see that nurse practitioner to adjust his medication?
That's the problem, is that we haven't been able to get in too quickly because we have to call probation and then probation has to contact you and then we have to get permission. So it hasn't been easy.
And if those restrictions were lifted, would it be easier for you and your family to get him the medication?
It would definitely be a whole lot easier.
Okay, can you tell me how being on full house arrest has affected my client's mental health?
Or it's affected his mental health and it's affected our mental health in the home, but his stress levels, he also has an eating disorder. When his stress levels go high, then groceries disappear and he can't go out to leave and stuff. Going out in the front yard is not doing anything. He hasn't been to a park, he hasn't been to a grocery store, he hasn't been.
And as part of the reason we're requesting this today to try to help get him in a better state with his mental health. Okay, and does he help care for his little sister?
Yes, he does.
How old is she?
She's 10 years old.
Okay, and is the full house arrest kind of inhibiting that as well?
Now,
Okay, and would you say that his symptoms have improved since he's been on that invective?
oh, yes. Yes.
Is there anything else you want to tell the court when the judge considers whether or not to grant him tracking only as a condition of his defense?
The only thing that I have to say is Arthur's not allowed to drive. We take him to and from wherever he needs to be. He doesn't have a driver's license and he's not allowed to drive. So if he goes anywhere, it will be with me or my mother.
Possible instruction.
State?
Thank you, Judge. I'm sorry, ma'am, I didn't catch your name.
Stephanie Good?
Are you aware of the facts of why Arthur's here?
Yes,
The
sir.
present case?
Yes, sir.
And so you're aware that it's alleged that he shot an individual?
Yes.
I cannot hear.
Sorry. Judge.
Everybody's whispering.
Have you known of Arthur having issues with firearms in the past?
No, sir.
But he had a case that was pending before with you as a victim,
Yes.
and in that case, it was alleged that he held a gun to your head, right?
No, not held it. No, sir, not held it to my head. He did not hold it to my head. That's what the police reported. That's not what I reported. And I went to the DDA and everyone else about that. He did not, he was trying to hurt himself. And they would not go help him.
But he was using a firearm in that.
He had
incident
a
also.
firearm in that incident, yes.
What was going on with him at that time to where
He was in a suicidal fit. He was in one of his rages. He had been off his medication for over 2 months. And that's a lot of what we go through.
was he off his medication during this present offense?
Yes, he was.
Your Honor, I'll pass the witness.
Ms. Good, are you aware of the resources that are available should my client suffer a mental episode like he has in? No.
Yes, ma'am, I am. That's why part of this is good things happen and bad things happen. I'm thankful that I have more people to help me have his medication on a regular basis, the more important.
I'll pass it.
Any other questions?
No, Your Honor.
I have a couple.
Okay.
Yes. So how old is your mother?
My mother,
Yes.
she is 68.
And who lives in the home now?
It's me, my mother, my daughter, and Arthur.
And so is he ever in the home by himself with just him and his younger sister?
Yes.
So sometimes it's just him and his younger sister and
Yes.
nobody else?
Yeah, but if my mom goes to the store or if I'm at work, yes, it could be them two at home. No.
Okay. All right, any other questions?
No, Your Honor.
Judge, I do have one exhibit that I'd like to enter as defense exhibit 1. It
All right,
is-
you may take a seat.
I'm sorry, Judge. It is a letter from True Mental Health Services from his case manager, or actually the director of Alexandria Mills. But I'd like to enter it as defense 1 at this time. It's attached to the motion.
No objection, Judge.
All right, the court will accept exhibit 1, which is attached to the motion. All right. The court has reviewed defendant's exhibit number 1. And if you will give that to the court reporter, please. All right, is there any more witnesses, defense?
No, just argument, Judge.
All right, state any witnesses.
No witnesses, Judge, I would just limit station visit. Copy of the office reports this case.
No objection. Ma'am.
All right. All right, the court will accept state's exhibit number 1 and review it. All right, the court will hear argument. Yes.
Your Honor,
Everyone, make sure you whisper.
my client was in custody for 5 months before he was able to make bond. He's been on full house arrest for 90 days, Judge. I believe that since the time of the incident to now, his progress towards keeping up with his mental health has improved drastically, Judge. From the letter from True Mental Health, not only is he participating, they keep commenting how increasing is, how his motivation is in this treatment, Judge. That injection that he's getting is long lasting, and the reason we're requesting this is to make sure that his mental health continues to improve, Judge. As you heard from Ms. Good, that he's not going to be without someone from his family. We're just requesting a little more leniency so he can go to the park, maybe a grocery store, Judge. He will be monitored still. We're not asking for removal of the monitor. Additionally, Judge, I know that you did read that offense report. However, there are there's at least one witness who does mention that the complaining witness says that he has a piece also, Judge, which probably is not reflected in that report. Also, what is not reflected in that report, and from my conversation with the state at the first setting, the complaining witness in this case also has cases pending against him as well, Judge. We're still pending on the competency eval to see how this case is going to be resolved, Judge. But until then, we're just asking for an opportunity for my client to have a little bit more freedom to go with his family to places he needs. If this court is concerned with him staying with his 10-year-old sister alone in the home, allowing tracking only so he can go on these errands with his family would alleviate that as well, Judge. So we're respectfully requesting that you consider tracking only into my client's compliance while on bond this far.
Right.
Judge, I believe we were here a few months past that. I guess the reason the defendant was able to get out of custody was because we agreed to lower his bond on the condition of full GPS hypertext. He has done well on full GPS. He's complying with medications. But obviously the concern is based on the facts of the case as well as what the witness testified to, is that he could be put in a situation to where he's a danger to others. Both instances, both the past incident involving his mom, as well as this one involved a firearm, where he escalated in this situation allegedly and shot someone. So we believe that it's important to limit his interactions with individuals, not only to, I guess, protect the defendant, but also society as a whole. So while we would agree to some modification, we do not believe that tracking only would be, we would be opposed to that.
Do you have an issue with curfew?
We would, Judge.
All right, so you just want him on full house arrest?
No, we would agree to partial to go to certain locations.
But not a curfew.
I don't think, I mean, because like this instance, Judge, it's alleged to have happened on a bus with a random individual. And so I don't think a curfew would prevent something like that from potentially happening again.
And Judge, we would not be opposed to an exclusion zone for via bus station or the complaining witness's address.
All right, and you're saying partial as to how?
For anything that's necessary, so doctor's appointments, if he needs to take his mom or needs to go with someone somewhere, grocery store, things like that. But I don't think like just walking around the neighborhood would be just considered necessary, Judge.
All right. What I can do is I'll start him off on partial, and with partial, what I'll allow is if he can go to any medical appointments that he has. He can go to the grocery store and places with his mother or either his grandmother, as long as they accompany him.
So he will be able to go to, as long as he's supervised.
Yes, he can go to the grocery store. If his grandmother, his mother are going to the grocery store, going to wherever they need to go for necessities, he's allowed to go with them. So we're going to start that off and see how that goes. And if that goes well, then you can come back in a couple of months and we'll see where we are from then.
Sure.
And of course, I know the holidays are coming up, so I want to see how that works out. But he will be allowed, unless there's an objection from the state, he will be allowed if there's Thanksgivings, events at some other relative's house, he will be allowed to go to that other relative's house. Do you have any objection to that?
No, Your Honor.
All right, so he will be allowed to participate in Thanksgiving celebrations with family, Christmas celebrations with family, but he has to be accompanied by an adult. And that adult can either be his mom or it can be his grandmother, because my understanding is those are the two people who know best about his issues and how to handle those. Yes.
I was wondering if I want to go to the gym, working out, I'll be stressing, I'll be trying to find some way to, unstress, I'll be doing push-ups and stuff, but that's not, I'm a big dude, you know.
Yeah, well, I will tell you this, Mr. Beecham. We're going on this step by step. So I want to see how this works out first. And then your attorney can come back in about 2 to 3 months. And if everything is working out, then the court can reconsider other things.
Yes, ma'am, thank you.
You're welcome. Is there anything else? All right. All right, the other thing we need to address, when is this set? Ms. Ferguson, can you look up?
December. It's December.
December 12th. All right, so it's December 12th. All right, so I will see you all back on December 12th. And if there's an issue with pretrial services who's monitoring him, just let the court know.
That's all I have, Judge. May I have your excuse?
Your excuse. Thank you. You're welcome. Jeremy Garcia. Hello.
Morning, Judge.
Good morning. All right, so we have a plea deadline date for him.
We've actually, he's been accepted into the PTD program.
Okay,
We signed the contract and just turned it in today.
all right, I need a PTD date for Jeremy Garcia. All right, we'll see you back on December 19th. Just
December
get
15th.
yes, get a reset form from Ms. Ferguson.
Thank you. And I assume if he gets in ahead of time, then that date may be canceled if this is the case.
It's possible, yes,
Okay.
yes.
All right. Thank you.
All right, thank you. Just get a reset form from Ms. Ferguson. Robert Carter. All right, and your client was a no-show last time. Is your client here?
My client is not here. I have not even tried to get custody since that date. I
Okay,
was told by the bailiff when I asked, he was not this lady, that he had been here and checked in,
no,
but I haven't seen him, and eventually I left.
no, he hasn't checked in.
Not today, I know he doesn't. I just found out from my office while I was here in the courthouse.
All right, I think he may be on a commercial bond. Have you tried contacting the bondsman to see?
I have not.
All right, if you want to, if you go to the back, the clerk will be able to give you the bondsman's name, if you want to call the bondsman and see if they have contact with him. All right, and then we'll recall this back by 10:30. Is that good for you, Mr. Young?
It's not.
Ah,
I have 200 cases that I'm in the middle of another court. Sort of jumped on top of those.
okay. All right, well, we can call this. Is there a prosecutor available? Court is calling 2022 CR 5930, State of Texas versus Robert David Carter. Could I have parties announced for the record for the state?
Marcus Sanders.
Defense?
John Young,
All right, this hearing was scheduled at 9 a.m. It is now 9:59 a.m. The defendant has not made an appearance. If one of the deputies could make the announcement to see if the Mr. Carter is outside.
Your Honor, I did go outside.
All right, so the deputy is informing the court that the defendant is not outside the courtroom. Defense, have you had any contact with your client?
Your Honor, I had made several attempts on the previous setting to get in touch with them. I have made no attempt since then. I did not receive notice of this until about an hour ago to be here myself. So I certainly have not been able to contact him today. If the court would allow me to attempt to bring him back on Friday, I will try and get in touch with him.
All right. And the court will note for the record that the defendant was a no-show on November 14th, which is the reason it was called for November 16th. But we will recall this. I'm sorry, the reason why it was recalled for, yes, November 16th, because he was a no-show on the 14th. We'll recall this for yes, we'll recall this for, thank you. You know, I was in my February calendar. We'll recall this for November 18th. And if your client does not show, then.
Then it'll be Katie by the door. I understand, Your Honor.
All right.
Thank you very much.
You're welcome. Francisco Reyes. Francisco Reyes going once.
I don't see the defense attorney.
Veronica Alvarez. Hello. Yes. Your client has a BF.
Yes, Your Honor, and speaking with the clerk and the bailiff and the clerk in the back and the PR bond, it's been a big mix-up. And so, and speaking with Norma, I believe that they thought that she was on bond, and that's why I was here on the 7th, Your Honor. You issued her, I guess, a BF on that day, and then I guess the clerks found out that she was in jail.
Mhm.
But that was not correct. She's not in jail. She's on a PR bond. She hasn't reported to a PR bond since July. I spoke with her mother and her aunt just now, and they don't know where she is. She doesn't have a phone. She calls in because her mother, the grandmother, has the kids. Typical. So at this point, Your Honor, I have no contact with her. She has no phone number. I have conferred with the state. They've given us an offer. I'm sure we can work it out if we just knew where she was. So I've left messages with the mother and the aunt to tell her to come to court today, now, ASAP. And they can't guarantee that they will be able to reach her because they don't know when they ever see her or talk to her.
All right, well, a warrant has already been issued for arrest. Is that in the system? But she's not.
I don't know. We keep getting, we're being told that she's in custody, but there was a glitch in the system.
So is she currently in custody now or no?
According to the bailiff, she's not, but the jail's telling us she is.
And Loopy said that he talked to the jail, and they don't have her in jail. But then in speaking with the mother, she indicated that she's out, but they don't quite know where she is. She's Probably on the street somewhere.
Can you mute me for a minute, please?
Beverly Zuniga? Beverly Zuniga? All right, the court is calling 2022 CR 2568, State of Texas versus Beverly Marie Zuniga. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
Defense?
Robert Gower for the defendant, Judge.
Are you Beverly Zuniga? I'm going to show you a document entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Beverly Marie Zuniga who was placed on community supervision in 2022 CR 2568 for the offense of assault family's second offense on April 14, 2022 for a term of 5 years? Is that you? State?
Violated condition number 4 in Bear County, Texas. The defendant Beverly Marie Zuniga, defendant there failed to report to the supervision officer as directed for the months of June and July 2022 in violation of condition number 4.
How do you plead to that? True or not true?
The state would waive and abandon the remaining allegations.
Any objections?
No objection, John.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to 5 years in prison? Did you understand?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there an agreement?
Yes, Your Honor. The agreement to deny the state's motion and alternate conditions to include bi-monthly reporting for 6 months and a TAP evaluation and follow recommendations.
Is that the agreement?
That is the agreement, Judge.
Are you asking the court to follow that agreement?
Yes, we are, Judge, and
No, I'm asking her. Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, defense, there's something you wish to address?
Judge, just wanted to make sure that could be released today and then making the appointment for the tap.
No.
I wonder.
Okay.
Just in case.
No. It will be while you're in custody. And let me just tell you the reason why. You haven't been reporting. So that's an issue. And that is one of the easier things to do while you're on probation is show up. And you haven't been showing up. So you want to explain to me why you have not been showing up?
I have a sick grandmother. She's 86 years old and she has a pacemaker. And I was working and I got caught up taking care of her. I don't have my parents, but I'm the oldest of my siblings, so I had to take care of her. And my aunt came back from out of town just recently while I've been in here, and she's taking care of her. So that's not gonna get itchy.
Working doing what?
At the chicken strip store.
Okay. Now, you're going to take the TAP evaluation while you're in custody. Why do they want a TAP evaluation from you?
Doesn't really know, Judge.
Well, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand. What's your your grandmother's name?
Maria Zuniga?
All right. And so are you living with her?
Yes.
Do you have children?
Yes.
Are your children living with her?
They're brown lady.
Okay. All right. This is, have you ever used drugs in the past?
No, ma'am.
All right, this is what the court is going to do. Deny the motion, alternate amend conditions for a TAP evaluation. That's to take place while in custody. If the recommendation is inpatient treatment, we'll start with intensive outpatient treatment and supportive meetings. I'm going to want field visits 2 times per month. And I'm going to want weekly reporting for 3 months. And that could be by Zoom or in person. And probation, you can let probation know part of those field visits can be a part of her reporting. And the weekly reporting for 3 months, if there are no issues, then we'll taper that off to 1 time per month. But I'm going to want the field visits 2 times per month until further notice. And tell them that they need to check on the grandmother that she's living with and make sure that the grandmother actually wants Ms. Zuniga living with her. And tell them to talk to the grandmother in private without Ms. Zuniga being present. And the defendant is to remain in custody until the TAP evaluation.
So once the TAP is done, good, it gets processed out.
Yes.
Okay, thank you.
Is there anything else?
Nothing further.
All right, thank you.
Thank you.
John Ayala.
Judge.
All right, let me find him on the docket.
He's on page 2, Judge, at the bottom.
Oh, you are so awesome.
That's so nice.
Wait, page 2. I'm looking at page 2 and I don't see him there.
Miscounted.
You know what? It's actually page 7 first, but you were right, page 2. What is happening with this case?
Judge, on this case, due to some of the sensitive issues involved in the case, I wanted to meet with the victim ahead of time. We had to reschedule since we were in trial, and we've reached out to try to get a new time to meet with them, hopefully sometime in the next couple of weeks. So we were just asked for another setting. I think it's only a second setting on this.
Okay. All right, Ms. Ferguson, I need this recalled in 1 month, please. All right, we'll come back on December 16th.
All right, thank you.
You're welcome.
See you tomorrow.
All right, you need a reset form.
Your Honor.
Yeah. Francisco Reyes. And where is Reyes?
Morning, Judge.
Good morning. What is happening with this case?
Your Honor, we received an offer from the state today. I'm still in the process of downloading the discovery associated with it. He does have a pending misdemeanor that we're also trying to resolve. So we can have it at a reset, get all, maybe get a room walker or potentially have to set these cases for trial.
All right, so this was set for a plea deadline for November 3rd. And I understand that we were in trial, and so probably that wasn't addressed. But I'm giving you another plea deadline date, and this will be the last plea deadline date. And if there's something you all going to work out, it needs to be worked out by this date. Ms. Ferguson, I need a December date. All right, your plea deadline date is December 16th, and the court will not extend your plea deadline date any further. Do you understand? All right, Ms. Ferguson will give you a reset form. You're welcome. All right, Brandon Richardson is going to be recalled for November 18th. All right, are you Mr. Ochoa? What is your name?
Jody Ochoa.
All right, Mr. Ochoa, we're going to recall your case for November 18th, and you can appear by Zoom, and that information will be given to you. It's being recalled back at the request of your attorney, okay?
November 18th.
Yes, November 18th.
Thank you, ma'am.
All right, you're welcome. Thanks for your patience. Have a great rest of your day.
Yes, ma'am. You have a blessed one.
Thank you. April Keeler. Hello.
That's some good news for you.
Hi.
I'd
Yes.
like some good news rather than bad news.
Oh, I'm always love good news. All right, Ms. Keeler, you were supposed to be here on the 15th. Is there a reason why you were not here?
Yes, ma'am, I wasn't doing well physically, and I was also waiting for the pre-trial diversion that I qualified.
Okay,
for.
so here's the thing. When you have a case that's set, you need to be in court. If there's an issue, a medical issue or something else, you need to call in, because otherwise I'm looking at my docket and you're just the person who didn't show, and you're just the person who's going to end up at the Bexar County Jail because a bond forfeiture is going to be issued. You understand?
Yes, ma'am. I'm so sorry.
All right, Ms. Ferguson, what date?
I can do this 14th.
All right, we'll see you back on December 14th, and Ms. Ferguson will give you your reset form.
Thank you so much.
All right, you're welcome.
God bless you.
Oh, thank you.
If she gets accepted into the program, should we just call and cancel the court date?
No, she needs to be here on December 14th.
Even if she's in the program?
She needs to be here on December 14th.
Okay.
Thank you. I heard it.
You're welcome.
Norma, do we need a reset or is that just it? Okay, I'll wait, I'll get you sent these there, so if you want to wait down through all the cheese. May we be excused after these.
Yes, after everyone signs the form.
Okay. I'm glad you got me down here, otherwise I'd be sitting at home laying in bed.
Oh, okay.
I feel much more productive now.
That's always
Have a
good.
day, Judge.
All right, thank you, you too.
Stay safe out there. I know that's not you though.
Who's here on David Burnham or Vernrun? Council, have you had a chance to confer with the state on this? Oh, okay.
But just to let you know, I was appointed on Mr. Barnum back in June. And he posted bond on the unauthorized use. And then a violation report was filed because he picked up 2 additional charges, a felony 2 and a felony 3.
Yes.
And Stephen Nicholas represents him on those 2 cases. My understanding is that he's out for medical reasons and he's not coming out of the apparently he's having some kind of surgery. And
All right. Are you able to take over these 2 cases?
I don't think felony 2s or 3s.
Uh,
My client is wanting to try to get some type of resolution, but we don't have the lab results on the 2 new cases anyway. So we're,
okay. Well, you want to talk to the state about this request for a PR bond?
sure. I can do that.
Okay. All right. Thank you. And I don't know, they may not have this, so let them see this.
Thank you, Judge. I'll give
All right,
this
you
right
can
now.
have a seat. You're welcome. You can have a seat.
Don't want it.
Running that. Okay, good. Yes. How many attorneys are there? Beautiful.
In other words, too much. I can close by looking at. Right.
Sure.
Sometimes he has to go for 220. I thought of you as soon as he did that. I thought, oh, I bet she'd scream.
Yes, I know. It's like, oh, it'll see what happens. Yes, sure.
And she has been changed from modify the positions. You need to go from this direction. And then you have to watch it. Thank you.
No.
All right, Ms. Thorne. I've been informed that your client is not at the Bear County Jail. And they have checked everywhere. She's not there. And it shows that the last time she was there, they're telling me was in July.
That's kind of what I thought.
Okay. All right, so,
Now your point is your.
yes.
Yes, that's right.
All right, so
May I
we're
be
gonna,
excused?
well, we're gonna go on the record.
Okay, yes.
All right, court is gonna call 2022 CR 9445. State of Texas versus Veronica Alvarez. Can I have parties announced for the record for the state,
Martin Sanders.
for the defense?
Sharon Thorne.
All right, this hearing was scheduled at 9 a.m. It is now 10:31 a.m. The defendant is not present. Deputy Laura, has there been an announcement made for Ms. Alvarez?
Yes, Your Honor, and Ms. Lance.
According to the deputy, there's been no answer made when the name of Veronica Alvarez was called. Defense, have you had in contact with your client?
No, Your Honor.
State?
They're arresting that are bond be forfeited and warrant issued.
All right, my understanding is that she is on a PR bond.
That's my understanding, and Ruthie and I checked with PR people. They gave us some numbers. Reached out to her mother from the numbers I got, and she has not seen or spoken to her daughter according to the mother.
All right, the court will issue a judge's warrant or remand your client without bond. If you're able to get in touch with your client and your client makes an appearance, the court will reconsider.
Thank you.
All right, yes, maybe excuse. Arthur Galindo. All right, what is happening with this case?
Your Honor,
You need to switch sides.
say
Thanks
that.
for dressing appropriately for court.
Thank you. Your Honor, we're gonna ask, say that's for one reset to set for trial. Is it's not currently set for trial?
No, okay, so was an offer tendered? Is that offer being rejected?
You have, I do have an offer, Your Honor.
All right, was that offer presented today?
Previously, Your Honor.
All right. Are you rejecting the offer?
Yes, Your Honor.
No, I'm asking your client.
Yes, Your Honor.
Are you requesting a jury trial?
Yes.
All right, so your plea deadline date has expired, so the court will not consider any plea bargain agreements in this case without good cause. Otherwise, if you decide to enter a plea, you'll need to enter a plea open to the court. Do you understand?
Yes.
All right, state, how long do you expect this case to last?
A couple of days, Judge.
All right, Ms. Ferguson, can I have a jury trial date for January?
I'm sending them the impact.
All right, what day? All right, you're going to be in jury trial December 5th. Right, court.
Your Honor.
All right, Ms. Ferguson, we'll give you a reset form.
Thank you.
You're welcome. Logan Armstrong. Is the attorney here for Logan Armstrong? All right, just have a seat. Katrina Goodwin.
President, Your Honor, ready.
All right, if you'll come forward. Court is calling 2017 CR 3456W, State of Texas versus Katrina Goodwin. Could I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
James C. Law.
And are you Miss? Thank you. And are you Miss Goodwin? To show you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, I know.
Are you the same Katrina Goodwin who was placed on deferred adjudication in 2017 CR 3456W for the offense of theft of property less than 200,000 on May 15th, 2017 for a period of 5 years? Is that you? State?
Condition number 5 in Bexar County, Texas, the defendant Katrina Goodwin did then and there fail to report to the supervision officer as directed for the months of January and February 2022. In violation of condition number 5.
How do you plead to that? True or not true?
We'll waive the others.
That's our agreement.
Any objections to the waivers?
No objection.
All right, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, and sentence you up to
10 years.
all right, so it is a motion to enter adjudication of guilt. Sorry about that. The court could sentence you up to 10 years in prison and up to $10,000 fine. Did you understand?
Yes,
Knowing that, do you still wish to plead true to violation of condition number 5?
yes.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Your Honor.
We're asking that you deny the motion, alter and amend your conditions to order DDRF, and that you remain in custody and trial.
All right, so DDRF, that's a 32-week rate.
Not for females, Your Honor, it's about 48 weeks.
Oh,
And Your Honor, I'm asking during that 8-week period, we're asking for a GPS monitor and have a release.
all right, that will be denied. Why are you not reporting? Because this is from felony drug court.
Yes.
So you failed. That's why you're back here, because you failed felony drug court. You didn't follow through. So I would like to know why you were not reporting to them.
I didn't report to them because went to the hospital, I had COVID, and I had proof, my hospital records stating that I had COVID. They thought I had meningitis, they went up.
I'm not considering the other allegations in this motion, but there are more than that in this motion. So are you trying to tell the court, and this is before I put you under oath, are you trying to tell the court that you only missed this reporting and you missed this reporting because you were in the hospital? So if I call someone from felony drug court to come over, is that what you're going to say?
No.
All right, so why are you trying to make it seem like you've been doing
Just
great?
That one, the first violation, yeah.
Go for.
You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand. So where have you been? When you were arrested, were you immediately placed in custody or were you out and about for a while?
I was out and
And what were you doing while you were out and about?
about.
Were you doing drugs?
No,
You're under oath.
yeah, I was out and about. I mean, I was staying here and staying there.
But what were you doing? Did you do drugs while you were out and about?
Yes,
So why are you pretending like you don't know what I'm talking about? So what drugs were you doing while you were out and about?
methamphetamine.
All right. So I have a person before me who's been kicked out of felony drug court. I don't know if she wants to do anything. I don't know if she just wants to go to prison.
She told me she wanted the in-house residency.
Yes,
She wants to try that. And I told her it's gonna be up to 6 months. A bed inside, you can't leave. And
So
she's
here-
too old to be doing that.
So here's the problem with people who have drug issues. Nobody knows until they're clean and sober if they have drug issues and mental health issues, or if it's just a drug issue that causes the mental health issues. So I don't know if DDRF is appropriate for her. Is there a reason why we think DDRF is appropriate for her?
It was the officer's recommendation, but I'm not sure exactly why.
That was a recommendation from the probation office.
Do you have mental health diagnosis?
No, I don't. Your Honor, it was notated that,
Bipolar.
I'm sorry.
Huh.
Your Honor, it was notated that she was diagnosed with bipolar disorder. And that's why. The bipolar disorder as well as the addiction, the methamphetamines.
All right, so let me ask you this. What is the wait time for ISF cognitive and substantive track?
Let me double check.
Yes.
I'm more familiar with the ISF. I'm not really real familiar with the other, they're offering me or what they're offering me, and ISF, the information that I've got, I've heard being in jail that it's a good program. I'm just saying, I don't know about the other program. I've not really heard about the in-house program.
So have you ever been on any medication for any mental health issues?
No,
For your bipolar.
no, the only thing I've been out on the free road is the diazepam.
Okay. Have you seen a psychiatrist before?
No.
Okay.
Your Honor, the wait time for state ISF is 70 days.
And DDRF is for how long?
48 weeks.
She's telling me she doesn't have a mental health issue.
Her record shows she has a diagnosis of bipolar.
All right, when's the last time you used drugs before you were taken into custody?
Maybe a week,
All right, and how long have you been in custody?
over a month.
All right. Is there any other drug facility inpatient that's available for her that's not as long? If it's not, I'll go ahead and do DDRF since that's what probation is recommending, but
Can you give me a few minutes? Your Honor?
yes.
No, I'm not in front of the judge.
Sometimes I don't understand. They're not. Yes. Yes, yes.
Your Honor, the wait time for state E would be about 17 days.
All right, thank you. So we're gonna do, the court will deny the motion, alternate amend conditions to include safety. And upon release from safety, she's gonna be on GPS, partial, and she'll be allowed to work and attend all medical appointments. And then if she's completed safety, see if felony drug court will take her back. All right, is there anything else?
That is it, Your Honor. Thank you very much for your consideration.
All right, you're welcome. Thank you. Good seeing you as always.
Thank you, Judge. Okay, good. You got a big break. You like that?
And probation, she's to remain in custody until transfer. Thank you. All right, who is here on Jonathan Ben? All right, and who is the interpreter for?
It's for John Winter.
All right. Are you all ready or no? right, can I see the file on Adon Silva? I have David Sanchez, Joe Lopez. All right, where's Mr. Silva? All right, if you'll come forward. All right, and we're not going to be on the record. Who's the prosecutor on Adon Silva? All right, so we were here on October 3rd, and there was supposed to be a criminal background check that was needed.
Oh, Judge, I don't know about that. I can, what kind of criminal background check on the?
I just have criminal background check needed, and we were supposed to be recalled. And it was actually for November 7th, but because we're in trial, we didn't take it on November 7th. But someone said that they didn't have a criminal background check. I don't know if it was for this defendant or for the complainant.
Because,
Thank you.
You know, there is an issue with possible alias for Mr. Silva. I think maybe that's what that is.
I think that, that may be correct. I think that there was a different name it was coming up for, but I believe we have it in here now.
Okay. All right, so do you have all the discovery?
Yes, Judge.
State, are you prepared, or were you prepared to make an offer?
I think did we make an offer?
No, you said that you wanted to.
Oh, okay. Because I don't believe we've made an offer yet. This is my first time looking at Judge, but I can make an offer to Mr. Winter before the next setting.
Okay. All right, Ms. Ferguson, can I have a 1 month reset for Mr. Silva? All right, we'll come back on December 14th. At that time, the state will make an offer.
Thank you, Judge.
All right, and one question, and of course, I mean no offense when I say this, but is your client a citizen?
No, you're.
All right, so do you have an immigration attorney for him, or you need one appointed?
Well, I guess we'd like to have an appointed immigration.
All right, Ms. Ferguson, he's going to need an immigration attorney. All right, thank you. All right, thank you. All right, if there is nothing else, he'll get a reset form.
Thank you.
All right, thank you. Thank you for coming. It's always great seeing you.
Right, one second, can I be excused?
Yes.
Thank you.
Who's here on Joe Lopez? All right. Well, we'll wait. Alfredo Hernandez.
We're ready, Judge.
All right. If he can come up, please.
Yes, Judge.
And probation, there's no application on this.
No.
Court is calling 2020 CR 10767, State of Texas versus Alfredo Hernandez. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
Defense?
Kelly Fiddle.
And are you Mr. Hernandez?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Hernandez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
State's just proceeding on count 1 and waiving and abandoning the repeat offender allegation. No objection.
All right. Mr. Hernandez, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I'm ready.
Did you understand you're charged with the offense of violation of protective order, bond, assault, stalking as a 3rd degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, I understand that.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
yes,
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to appeal. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, state is proceeding on count one. Punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. There are no applications. The state will take in consideration night mag number 685747. There's an affirmative finding of family violence. There's to be no contact with Alicia, Alisha, Vega, Vega. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Ma'am.
Defense is at the plea?
yes,
State is at the plea.
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No.
Then to the offense as charged in count one, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, sir. At this time, data for state exhibit number 1 and its attachments.
no objection,
Mr. Hernandez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, judgments, and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are we proceeding with sentencing?
yes, sir.
Anything you wish to say on behalf of your client?
So we just ask you follow the word.
All right, Mr. Hernandez, why should I follow this plea bargain agreement? It appears that you don't understand simple terms like do not contact somebody.
I'm just gonna say, ma'am.
I'm sorry?
I don't have anything to say.
Well, you gave up your right to remain silent, so I'm asking you to say,
Say what, ma'am?
why don't you understand that you're not to have contact with somebody? Why do you think it's okay to put your hands on somebody? why do you have a problem with Ms. Vega letting the father of her other children come over and see her children?
I don't talk to her anymore.
Why don't you understand?
I don't talk to her anymore.
No, but you were talking to her on this day and you were talking to her violently. So my question to you is, what don't you understand?
I understand everything.
Obviously you don't. Do you want a jury trial?
No, I don't understand. I'm gonna just stay quiet.
No. Do you want a jury trial? Yes or no?
Do you want the judge to follow the plea bargain and give you 3 years to pursue, or do you want a jury trial?
So my question to you is, what don't you understand? So from reading this police report, there is an order for you not to have any contact. So you disobeyed that order and had contact anyway. And not only did you have contact, but you were violent. So I'm trying to figure out, what don't you understand?
I understand.
So why did you do it?
I don't know.
Do y'all want to discuss more than 3 years?
No, Judge.
I will be willing to give him 4 years.
Judge, we, when I had met with the complainant in this case, she had invited him over. But it does not excuse the assaultive behavior. Mr. Hernandez is asking the court to follow the plea bargain.
I would be willing to give him 4 years.
And Judge, just part of the contemplation of the state is the victim's willingness to proceed to trial. And so that was contemplated in reaching a plea bargain today.
Mr. Piddle?
Judge, we're asking in consideration in light of that information for Mr. Vieira that we follow the plea bargain.
And state.
I will tell you, Judge, that this is not information that Mr. Piddle did not know about her willingness to proceed. And her reasons for not wanting to necessarily participate. But that was all considered in reaching the plea bargain today, knowing that obviously things can change in the future, and trying to mitigate any potential issues from both sides in the future.
All right, the court will sentence you to 3 years prison, taking consideration NIGHTMAG number 685747. There's affirmative finding of family violence, and there's to be no contact with Alicia Vega. Is there anything else from either side with regards to sentencing?
No, Judge.
Nothing further from the state. Thank you, Judge.
You're welcome. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Right.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, and because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, I do.
You're gonna have to, we're off the record, you're gonna have to start doing better with your life. Otherwise, you're gonna spend a majority of your life in prison. Do you understand?
Yes, ma'am.
All right, good luck.
Thank you.
Who's here on Joe Lopez?
I'm here, Judge. Sure. 1 second, Judge.
Sure. All right, while they're talking, David Sanchez.
Good morning, yes.
Good morning. Oh, he's in the middle.
Every court is different.
Yes. And Mr. Sanchez, thank you for dressing appropriately for court. All right, so what is happening with Mr. Sanchez's case?
Judge, on this one, I need to talk to the victim before I make an offer. And so I'm attempting contact.
All right. And have you received all the discovery? All right, Ms. Ferguson, I need a 30-day reset on Mr. Sanchez. All right, we'll be back on December 14th. At that time, the state will be prepared to make you an offer. Just get a reset form from Ms. Ferguson, then you're excused.
Thank you, Your Honor.
You're welcome.
Have a good day.
All right, you too. Always great seeing you.
Congratulations.
Oh, thank you so much. Always great seeing you. All right, are we ready on Lopez?
It's gonna be a plea bargain.
All right, thank you. This is gonna be a plea. Is the attorney here for Logan Armstrong? All right, come forward. All right, the court is calling 2022 CR 8297. And if I could have everyone in the box be silent while we're on the record, please. State of Texas versus Logan Armstrong. Could I have parties announced for the record for the state?
Brittany Sparks.
Defense?
Michael Latimer.
And are you Miss Armstrong? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client? Court will find that the state is in compliance with discovery. Ms. Armstrong, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes.
Ms. Armstrong, I'm showing you what's entitled court's admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of evading arrest, detention with a vehicle? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Armstrong, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived a right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it? According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. The state opposes your application and they're taking in consideration 2022 CR 8298. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been any such motions?
No.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge. State Exhibit 1 and all attachments.
We reviewed no objection.
Ms. Armstrong, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We will come back on December 19th at 9 a.m. For sentencing. At that time, I'll make a decision on whether or not I will grant your application. That decision will be based upon any evidence I received from your counsel or from the state, and also any information from the PSI report.
I do want to speak for the record, Your Honor. There was a third charge against Ms. Armstrong, the night mag number 611183, and I've been informed by the state that that case was rejected, so we didn't need to address it first.
Okay. All right, and Ms. Armstrong, you were late for court today. Why?
I'm sorry, I was on time.
No, that's why you're sitting on the front row, because you were late.
Yeah, you weren't here at 9 o'clock. Were you here at 9 o'clock?
No, she was not here at 9, because I called the docket at 9. So you need to make sure that you're on time. The court doesn't tolerate people being late for court. Sometimes I give people a little leeway if it's raining, if the weather is bad, even though I'm here at 9 and people should make allowances for traffic. But do not be late for your appointments with probation. You understand? All right. All right, probation will speak with you. Oh, I'm sorry, counsel, do you want a TAP evaluation?
Oh, yes, please.
All right, that's going to be a TAP evaluation as well. I'm sorry, this goes with that. Who's here on Untabasi?
I'm your judge.
Hi. All right, where are we on the cell phone record extraction?
So Judge, I actually gave Mr. Sanders some printouts of his cell phone text messages and questions. But we've got another discovery matter that we've been working through and we've been talking actively. But we're still conferring on that, Judge.
Okay, what is the other discovery issue?
Some potential video recording footage at an apartment complex, which is the alleged scene of the offense.
All right, and where's your client? I know he's in custody.
He's right
Come
there.
forward. Come forward. So you need the recording footage at the apartment. Does anyone know if that still exists or not?
You know, Judge, at the time the case came in, it was past 30 days, but we're gonna give it a shot because it can support our defense and then aid in Mr. Sanders' evaluation. But potentially too.
Okay. All right, we'll come back on. I need a month reset. All right, we'll come back on December 14th to see where we are with the discovery issues.
Judge,
You're welcome. Is there anything else?
not to try to this time, Judge, just that we've talked about this, my client and I, so he understands this communication process.
All right, thank you. All right, they'll take you back. Who's here on Jason Galfo?
Judge, I'm ready.
All right, if you come forward. All right. What's happening with this case?
Judge, we're cleaning this out. We have to turn in the paperwork.
Oh, okay, thank you. Okay. All right, the court is calling 2022 CR 6684, State of Texas versus Jason Paul Galfo. Can I have parties announced for the record for the state?
Brittany Sparks.
Defense?
Linda Corley.
And are you Mr. Galfo? You're gonna need to speak up so I can hear. And everyone in the box, I'm gonna need you all to be quiet while we're on the record. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I reviewed the discovery with my client and I have received everything on the discovery acknowledgement index. I'm not aware of any outstanding discovery.
Right. Court will find that the state is in compliance with discovery. Mr. Galfo, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it? Next, I'm going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Galfo, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're being charged with the offense of felon in possession of a weapon as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel had, I'm sorry, Mr. Galfo. Just 1 second. Everyone, just give me a moment, please. All right, counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Galfo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea bargaining agreement, punishment is to be assessed at 4 years in the prison. The state recommends community supervision. They will take in consideration 2022 CR 6683. Did you understand that to be the plea? Defense?
Yes, ma'am.
State?
Yes.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
There are not.
Next, I'm showing you outside the plea bargaining agreement. State is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation and 150 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, the state exhibit 1 and all attachments.
No objections, Your Honor.
Mr. Galfo, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, he is appreciative of the opportunity to have probation. He is going to work very hard, trying to get everything done as early as possible and following the requirements of the court.
All right, Mr. Galfo, when you're drug tested today, what are the results going to be? And what are you going to be positive for? How often are you using? All right, when's the last time you used? All right, do you need to speak up so that you need to speak up so she can hear? Do you have children? What are their ages? Just a 3-year-old? Is that 3-year-old living with you? Is any of your family supporting you? Where is your family? Are they in San Antonio?
It's just my father, but he's in Israel right now.
Are you employed? What do you do?
Maintenance for a hotel.
When did you first start using drugs?
After I got out of the military.
So what do you do in your off time?
So I worked a lot.
Okay.
I'm either working or helping my father.
I'm sorry, sir, I can't hear you.
Either working or helping out my father.
All right. Okay, this is what the court is going to do. The court is going to follow your agreement, sentence you to 4 years in the prison, suspended and probated for 4 years. Take in consideration 2022 CR 6683. And are you using any other drugs other than meth? Anything else? All right, while you're on probation, you're not allowed to drink alcohol either. You understand? All right. There's going to be 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that, but if you do, 40 of those hours will be waived. I'm going to want parenting classes. with Triple T. Once that's completed, the remaining of the community service hours will be satisfied. I'm going to want regular reporting in person or by Zoom. I'm going to want field visits 3 times per month. There's to be no unsupervised contact with minors. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I'm going to want a TAP evaluation done. And if this TAP evaluation recommends inpatient treatment, we're going to start with intensive outpatient treatment. And I'm going to want 90 sober meetings in 90 days. And we'll do a referral to felony drug court. I know felony drug court is at capacity, but he can at least be placed on the waiting list. And we're going to do the UA hotline. And with that UA hotline, he needs to at least test once a week. And that UA hotline is until further notice. And once you are in a program and on your road to being sober for a length of time, then the court may change the UA hotline. You understand? Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful?
Judge Fan?
Yes.
On the 90 days, sober meetings, is that, are you saying AA? Or-
Yes.
Okay,
AA or NA?
okay, and that doesn't need to be consecutive or?
Yes, it needs to be consecutive.
Go every day?
Yes.
Okay.
I don't know. They call them sober meetings now. Why? I don't know. Yeah. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? And you were late today. Do not be late for your appointments with probation. You understand? All right, good luck to you. Better change your ways. We're off the record. As I tell everyone, when people are making drugs for sale, meth and all the illegal drugs, they're not going through FDA approval. They're just trying to make a sale. And when you use, the last time you use could be the last time you use. So don't let that happen to you, and don't let your son or your daughter see that. All right. All right. Good luck to you. All right. Kayla Rolag, is she on bond? All right. If you can come forward, please. What page is she on? Thank you. All right, Ms. Roleg, we're going to give you a reset at the request of your defense attorney, okay? Let's recall this in a month.
Can I ask for something?
Yes.
Can I take this to tracking instead of house arrest? Because I need to take my daughter, like, I'm having to ask my friend and my mom to take my daughter to daycare for me. I can't go shopping for groceries. I can't take her to the park, and it's like really stressing her out because I'm sorry.
All right, so let me just explain something to you right now, and I want you to internalize what I'm saying. 1, your attorney needs to do that. 2, you're before me with the charge of abandoning a child with risk of bodily injury, and I'm assuming this is the child you want to take places.
Yeah.
You also have an assault bodily injury family case that's out of 13. You also have a continuous violence case, and you also have an evading arrest of detention. So no. Thank you. All right, so what day?
December 14th.
All right, we'll be back on December 14th. And if you're drug tested today, what will the results be? Okay. Are the parties here on Christopher Ritchie?
Yes, Judge, I'm here.
Hello, hi. So have you all had a chance to discuss this?
I
with the
didn't
state?
discuss it with the prosecutor, Judge.
All right, if you want to speak with them about that.
Yes.
Jonathan Ben. Who's the attorney? Just have a seat. Who's the attorney for Jonathan Ben? All right, come forward. Court is calling 2022 CR 10909W, State of Texas versus Jonathan Ben. Could I have parties announced for the record for the state, for the defense?
Andrew Fred.
And are you Mr. Ben?
Yes.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ben, I'm going to show you what's entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up that right?
Yes, ma'am.
And did you understand that your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes.
And did you understand by entering this plea bargain agreement, you were giving up those rights as well?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you a document entitled Application for Deferred Adjudication or Community Supervision.
Judge, I fill out both of those. It's kind of an open plea. You're asking for probation, whether it's deferred or an actual conviction is
Okay.
up to the court, but I just need to fill out both just in case.
All right, did you review that document with your attorney? Did you understand it, and did you sign it?
No.
Next, I'm showing you what's entitled Information. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the information?
Absolutely.
State, are you proceeding on the information as presented?
Yes.
Mr. Penn, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with theft under $2,500 enhanced as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yeah.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ben, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. The state opposes your application. Did you understand that to be the plea?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. The state opposes your application. Did you understand that to be the plea? Defense,
Yes, Your Honor, we're applying for community supervision.
state.
Yes.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been any such motions? Then to the offenses charged in the in the information, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge, state exhibit 1 and all attachments.
No objections.
Mr. Ben, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court has reviewed the same. The court has accepted into evidence. The court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Will we come back on December 19th? At that time, I will let you know my decision on your applications. Yes.
I'm on vacation from the 17th all the way through after Christmas time. We could do it before then, that would be great. You could also waive PSI based on the information presented. I understand Ms. Sparks has a number of priors that she could introduce. There,
Yeah, yes.
and we can stipulate to those, Your Honor, if you want to waive PSI before today.
No, I mean, there are more issues
I
here.
understand.
Yes.
And I understand that,
So when will you be out of town?
starting on the 17th is a Saturday, so I'll be available anytime. Sorry, I didn't speak for you.
You need at least what? Yeah, they need at least 4 weeks. I don't know. Are you able to do it by Zoom?
From a hotel room. I assume that I can figure it out. Yes, Your Honor.
Do you want to do it by Zoom? Because otherwise we'll just have to push you back after the holidays.
Reply for my client needs to, yeah, I will absolutely be available whenever you. If I can be in a different state and do it, I will do it, Your Honor.
All right, so we'll put you by Zoom. Let Ms. Ferguson know that defense counsel is going to be by Zoom. Are you requesting a TAP evaluation?
Are we requesting it? Not necessarily, but
Yes. All right,
I'm assuming the Spark would request a TAP evaluation.
okay. All right, on Jonathan Ben, it's going to be a TAP evaluation and a PSI. And it'll be at 9 o'clock. And Mr. Ben, I'll base my decision on your application based upon the PSI report I receive and any other evidence that's presented to me.
Thank you.
All right, thank you. Who's here on Corin Campbell? Oh, just 1 sec. I'll take you up next. All right, what is with Corin Campbell?
Yeah, this is a second motion to modify bond condition.
All right, Ms. Ferguson, is Judge Nahara available to hear this motion? All right, so what is before we go on the record, what's the issue with the bond?
If you recall, Your Honor, this is a aggravated assault with a deadly weapon. I believe that this is a actual innocence case. It's actually.
So I mean, what are you asking for with regards to bond?
When he was arrested in July, it was full house arrest, and September 30th, he removed that full house arrest to lock him to work. Now he would like to be able to get off it completely. He complied with all conditions of the monitor, complied with any pretrial. He has a job, he's got a son. The location of where he is in regards to his son and school, it's caused him great difficulty in working, having to pick up his child at school, having to drop his son off at school, and also get to his job.
All right, State, are you opposed?
we're opposed to removing that, we would agree to.
All right, so they said they're in agreement to tracking. So is that an agreement, or you all still want your hearing?
No, if the tracking is gonna allow him to pick up his son, take him to school and all that, that's
It's,
fine.
it's tracking. And why were you late for court today?
Oh, no excuse, it won't happen again.
All right, if it happens again, we may be hearing your case from you being brought over, you understand?
Yes, ma'am.
All right, so where are we on this case other than that? So the court is going to give him tracking as agreed to. So if you all will fill out the appropriate motion.
At the last hearing, Judge, you signed an order on discovery and I'm still working on it.
Okay,
Yes, you made several rulings on the pre-trial and orders, and I also, and a couple of items you asked for a discovery order. I prepared that discovery order and forwarded that to Mr. Sanders, I believe, yesterday or the day before.
all right, Ms. Ferguson, let's recall this in 1 month. And we'll see where we are on the discovery issues. All right, we'll come back on December 14th for discovery issues.
All right, thank you, Your Honor.
All right, and if you'll prepare that other motion for the tracking only, the court will sign it.
Motion for track. Thank you.
And make sure the state signs off on it. Ms. Garcia?
Yes, Judge. I've come to an agreement with the prosecutor as to what we believe is their bond.
Okay. If you all, and that's for Richie?
That's correct. Judge.
All right, if you all want to do a, because did you file a motion or no?
No, because we were asking for the PR bond, just, but the state was opposed to the PR bond.
All
I
right.
personally don't believe he qualifies for a PR bond, and so
All right.
I know he doesn't.
Yes. All right, if you will go to the back with the clerk and have them pull the B pages for each of these. And if you all will write your agreement on there.
Okay.
All right, thank you.
Thank you, Judge.
You're welcome. Jake Gomez. Court is calling 2022 CR 7320 State of Texas versus Jake Gomez. Could I have parties announced for the record for the state? For the defense?
Kelly Fiddle.
And are you Mr. Gomez?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery? Did you review it with your client?
Yes, we did.
Court will find that the state is in compliance with discovery. Showing you what's entitled application for community supervision. Did you sign that and did you review that with your attorney?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
No, Judge, we're proceeding on count 1, waiving count 2 and the enhancement paragraph.
Any objection?
No objection.
I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession with intent to deliver a controlled substance? Penalty group 2A, 4 to 400 grams. That's a first degree felony. Range of punishment is anywhere from 5 to 99 years in life and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he is currently competent and was legally sane at the time of the offense?
Yes.
Mr. Gomez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one. Punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. State recommends community supervision, and there's $57 restitution for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Judge.
Showing you the paragraph entitled waiver repeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offer states exhibit 1 and its attachments.
Objection.
Mr. Gomez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports and laboratory reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
There you go.
All right, Mr. Gomez, do you have any children?
Yes, I do.
What are their ages?
23 and 18.
Do you have family here in San Antonio?
Yes, ma'am.
What family do you have here?
I got my tia, my aunts, I got my wife.
Does your wife have any children?
Yes, she does.
What are their ages?
23, 19, 18. Yes, sir.
That's it?
Yes, sir.
And where do they live?
They live on their own.
When's the last time you had employment?
Probably about a year ago.
Why?
No reason.
Then how were you supporting yourself?
I wasn't, Your Honor. I mean,
Who was supporting you?
my wife.
Have you been using any drugs?
When I was out there and when I was free, yes, I was.
What were you using?
Marijuana, methamphetamine.
Who is Desiree Gomez?
That's my wife.
And who is Nikita Housley? Nikita Housley. Housey, I'm sorry. Hausey. The person who lives in Kingsville, Texas. Who is that?
I don't know.
So how often is Desiree using?
She's on methadone. So I mean, she hasn't been using. I'm the only one that's been using on the pool.
Here's the thing, do you love her?
Yes, ma'am.
Well, if you love her, you can't be using drugs around her.
Yes, ma'am.
Because what's going to end up happening is she's going to fall off the wagon, which I think of methadone as a drug as well, because it messes with your cognitive abilities. Yeah, that's going to be an issue. I'm not going to let you live with her until you're in your sobriety. You understand? All right, this is what the court is going to do. The court is going to sentence you to 5 years in prison, suspended and probated for 5 years. Do you have any gang affiliation? All right, I'm going to have probation run it. If they run it, what are they going to find?
An ex-gang member.
All right, what? For what?
Order home.
All right, I'm going to want gang supervision. There's to be regular reporting by Zoom or in person. There's to be no contact with Desiree Gomez until further notice. There's to be no contact with Nikita Halsey. Proof of employment within 30 days of release. There's to be no employment as a home health care provider with minors. There's going to be a TAP evaluation while in custody. If TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. I'm going to want the UA hotline upon release. And that'll be until further notice. And upon release, I'm going to want 90 meetings in 90 days. There's to be no unsupervised contact with minors. I'm going to want field visits 3 times per month. Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful? All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Yes, sir. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yes, ma'am. All right, we can go off the record. I'm sorry. All right, I know you probably think I'm being mean because I'm not letting you have contact with your wife, but this is what I know about drug addiction. 2 people who have addiction, they can't be around each other until they are in sobriety. And right now, you're not in your sobriety. You're still using. If I were to release you right now, you probably use. I know your intention would not be. Your intention would be to get out. I'm going to do better. I don't want to go to prison. I'm going to work everything out. But what ends up happening is stumbling blocks come along in our life. And when we're not equipped to handle them, we go back to what we knew before. And what you knew before is using drugs. And so even though it probably seems that I'm being cruel, not allowing you to have contact with your wife, I'm trying to do what I can do to make sure that you're successful on this probation and not go to prison. You understand? Yes, ma'am. All right, good luck to you.
Thank you.
You're welcome. Oh, 90 days, 90 meetings in 90 days. This is sober meetings. Okay, I guess I need to, I'm gonna try to stop writing in code. All right, so I'm signing your document.
Thank you, Judge.
You're welcome.
May I be excused after
Yes.
this? Do you want me to take that to the back?
Yes.
Okay.
There you are. Good seeing you as always.
Good to see you too.
All right, you too. Everyone, I'm going to take a 5-minute break, only 5 minutes. Um, all right, who's here on Sergio Martinez?
I am your honor.
All right, hello, how are you doing?
I'm doing fine. How are you this morning?
Oh, it's a beautiful day. The weather is great. How's your wife doing?
She's a lot better, thank you.
Oh, that is so awesome. So where is Mr. Sergio Martinez?
Right over here in the box.
All right, Mr. Martinez, if you come up, please. State, have you had a chance to review the PSI report?
Yes, Judge.
Okay. All right, the court is calling 2022 CR 7495, State of Texas versus Sergio Martinez. Could I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Michael J. Sawyer.
And are you Mr. Martinez?
Yes, ma'am.
We're here for sentencing. You entered a plea. Sorry. No, you always have to answer calls for mom. That's what I tell everyone. You only get one.
That's my belief.
Right. All right. So we're back on the record. Mr. Martinez, you entered a plea to paragraph B of no contest on October 4th. And we're back now for the court to make a decision on your application for deferred adjudication or community supervision. According to the plea bargaining agreement, punishment is to be assessed at 5 years. There's restitution and no contact orders. The state is opposed to your applications. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Defense says, yes, ma'am.
Any objection to the PSI report, state?
None from the state.
None
Defense?
from the defense.
All right, are there any witnesses, state or defense?
No, Your Honor.
Defense?
No, you're right. His family is here that is here to observe, goes before.
All right, state, you're opposed. You may proceed.
Yes, Judge. We are opposed for a couple of reasons. I'll start off with his criminal history. As you can see in the PSI, he's been given opportunities at probation before. He was placed on deferred. He completed that, but then he picked up another offense right after in August of 2017. And that one, it looks like a motion and adjudicate was entered, but it was withdrawn. He then picked up an ABI. He was booked on that. He was granted probation for a year. In May of this year, and then that's when he picked up this offense while on probation for that misdemeanor ABI. Obviously, being on probation hasn't stopped him from committing the offenses. It's actually escalating. In this offense, he burglarized someone's home. He stole jewelry and other items and pawned them. As you can see, she was able to get the money through insurance, but she'll never have that jewelry back. As with any burglary, that's something that a victim can't come back from. Their home has been violated and there's no removing the stain of that. Based on the offense as well as his criminal history, we're asking that you deny his application for deferred or probation.
All right, defense.
If I have my client put on the road, you know.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God.
Yes, ma'am.
You can lower your hand, state your name for the record.
Sergio Martinez.
All right.
Sergio, how old are you? And you tell Judge Boyd, how far did you go in our school system? What grade did you? Made to the ninth grade. Do you read and write very well? Not too well.
I'm sorry, I can't hear you.
I could read a little bit. You don't read books and so forth. You're not a real literate person, right? You know enough read just to get by. Part of the problem you've had getting a job and maintaining employment because you really don't read and write very well, and it's limits the kind of job you can get. I've been a problem getting and maintaining steady employment. And I believe you are in a relationship. You have 2 children. Is that correct? Yes, sir. As you know, the judge can send you to prison today, where the judge has to put you in probation. We talked about this. And I explained to you that probation is not simple. In fact, it's very hard. You recall that conversation? You can go down to prison, do some more time, turn right around, come right back. You can go back to your old ways. That's a possibility. I tell Judge Boyd today, do you want to go back to your old ways? Or do you want a chance to get job counseling? Something to help your education, to help you maintain a real job instead of stealing for a living? How can you tell Judge Boyd you really want to make a change in your life and have her believe it and not just be here telling the same story the judge has to hear every day, 5 days a week? Why should she believe you? Yes. Do you think it's time to grow up and start trying to support your family?
Okay, I cannot understand.
Going to do some spring, little string of doctrines and stuff. So I
A
really
little
don't
what?
remember all that.
Don't understand what you're saying. What did you say?
What he's saying, you know, at the time of his he's had a drug problem for quite a while. The day this incident occurred, we talked about it. He's telling you, he doesn't even remember what actually happened that day.
But
He knows it is him because it's identified through a photograph and he agreed that was him.
But it says that he doesn't have he says that he doesn't have a drug problem.
No, I do have a drug problem. I never said that.
Okay, so that's what's incorrect in the report. All right.
And I think you've actually benefit from a structured environment, conditions of probation, job counseling, employment, and having a structure in his life. I think you could benefit a lot more from that rather than just going out of prison and being released in a few months, coming back without any help at all. And he knows full well, if he gets probation and doesn't live with a program, if he's standing right back before your honor, being sentenced to prison, he's aware of that.
All right, Mr. Martinez, what do you want to say?
You just gave me a chance. If I could change my life, I would like around.
Why do you need to be on probation to change your life? Why can't you do right? Life is so simple. It's just don't break any laws.
I know that.
So why can't you do right? And your counselor is telling me about your lack of schooling, but it doesn't stop you from stealing and taking what doesn't belong to you.
But you know you're convicted, you did this crime, you committed, you know you did wrong.
What's with
State
that?
point, cause monetary loss or stuff can never be replaced, you know that.
And what's with that Texas symbol on your hand?
Texas.
But you don't know you're in the state of Texas? What's up with that Texas tattoo on your hand? And what's up with that tattoo on your arm? That's what I want to know about.
This is tomorrow.
Mhm.
That's my simple.
All right, so you put it there. What, you can't remember your son's name?
Just something that I love.
All right, so what is the Texas tattoo about?
Texas.
You need that to know that you're from Texas?
No. Just like the Texas sign.
When did you get that tattoo?
7 months ago.
I'm sorry, when?
7 months ago.
What did you say? Did it-
7.
7 months ago? Okay. All right, anything else from either side?
No, Your Honor.
No, Your Honor, I believe everything you need to guide you make a decision contained in that PSI, Your Honor.
All right, so I'll note that the defendant has never been on felony probation. What I can tell you is you're not going home today. You're either going to prison or either you're going to safety. And you're going to remain in custody till you get transferred to safety. Safety is a 9-month-long program, and then it's 6 months of aftercare. I'm not going to let you live with your parents because you're old enough to have a lot of children. So you're old enough to live on your own and support yourself and not depend on other people supporting you. Or I can send you to prison for 4 years. Which would you prefer?
The PSI.
I'm sorry.
One use one right now. 9 months.
Okay. All right. This is what the court will do. Court is going to sentence you to 8 years, deferred adjudication. What that means, if you're not successful on this probation, I can sentence you up to 20 years in prison. Do you understand? And that 20 years is more than the 5 the state wanted. You understand? He's to remain in custody until transfer to safety, followed by aftercare. And after he's released from safety, see if felony drug court, is probation in here?
Yes, Your Honor.
Oh, hi, okay. See if felony drug court, you're all over the place. Sorry, but then you're multitasking. It's great to see. All right, followed by aftercare, and then put him on the felony drug court wait list. There's going to be regular reporting upon release. UA hotline until further notice. I'm going to want field visits 3 times per month. And we'll do an evaluation for gang affiliation. I don't know what's happened at the Bexar County Jail since he's been there. I'm going to want proof of employment within 30 days of release. There's to be no employment as a home health care provider with minors. 200 hours community service restitution, 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Parenting classes with Triple T, once that's completed, the remaining of the hours will be waived. There's to be no unsupervised contact with minors. Defendant is not allowed to reside with minors. And you know why I'm putting that in there? Because I don't want you living with the mother of your child and her financially supporting you, which usually is what ends up happening. So you're not to reside in any household that has minors, and you're not to reside with your mother, father, grandmother, or grandfather. You understand?
Yes, sir.
And there's to be restitution and no contact with Teresa Sheets. And that's SCHEETS. Probation, is there anything else that's needed?
I don't think so.
UA.
Yes, hotline. Is there anything else you need from the court in order to be successful? Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review this document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. We're off the record from here on out. Everything you do, you need to ask yourself one question. And that question needs to be, is the decision I'm making something that could potentially result in me going to prison for 20 years? And if the answer is yes, maybe, I don't know, you shouldn't be doing it. Do you understand? All right, good luck to you.
That's all I have. Have excuse.
Yes.
Have a good day.
Thank you, you too. Who's here on David Burnham? All right, if you come forward, please. Court is calling 2022 CR 10910W, State of Texas versus David Burnham. Could I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
I'm gonna read this.
And are you David Burnham? Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Burnham, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it? Next, I'm going to show you what's entitled waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that with your attorney? Did you understand it? And did you sign it? Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not there's sufficient evidence to hold you over for trial? Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand by entering this plea bargain agreement, you were giving up all of these rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled information. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
Mr. Vernon, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Burnham, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
Your Honor.
Are you satisfied with the way you've been represented?
Very.
Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm going to show you the plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea bargain agreement, there's $1,000 fine. State recommends deferred adjudication. They will take in consideration NIMAG number 683833 and 683832. And there's to be restitution and no contact with David Ruiz. Did you understand that to be the agreement?
Yes, Your Honor.
Defense?
Yes, sure.
State?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions? Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 120 hours community service restitution, and CATS 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense is charged in the information. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, the state offers states exhibit 1 and its attachments.
Mr. Vernon, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court deferred finding the guilt as you applied for deferred adjudication. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
We're just asking the court to follow the plea bargain. This is his first
I'm sorry,
felony.
ma'am, I need you to speak up, please.
This is his first felony arrest. He has no prior felony convictions. We're asking the court to follow the plea bargain.
All right, Mr. Burnham, do you have any children?
No, Your Honor.
Do you have any family here?
Yes,
Who do you live with?
I live with my mother.
Are you employed?
Not at the moment.
Were you ever employed?
Yes, ma'am.
When's the last time you had employment before you were arrested?
About 3 weeks,
How old are you?
29.
And you said no children? All right. Have you ever used drugs in the past?
Yes, Your Honor.
What have you used?
Methamphetamine and marijuana.
When's the last time you used before you were arrested?
The day I was arrested.
All right. This is what the court is going to do. The court is going to sentence you to 5 years deferred adjudication. There's $1,000 fine that will be probated. What is your mom's name?
Lisa, no.
Last name?
NOLL.
There is the court will take in consideration NIMAG numbers 683833, 683832. There's to be no contact and restitution to David Ruiz. There's going to be a TAP evaluation while in custody. If the TAP evaluation recommends inpatient treatment, we'll start with intensive outpatient treatment. You need to be honest in that TAP. There's going to be the UA hotline until further notice upon release. 90 meetings in 90 days. Proof of employment within 30 days of release. There should be no employment as a home health care provider or with minors. There should be no unsupervised contact with minors. 120 hours of community service restitution. How far did you go in school?
Went, a year
A year.
in, college.
Okay, why are you not doing anything with your life?
I was getting back into it, then COVID happened, and then.
A lot of people still went to school during COVID. I know people who got their law degree and COVID was happening. So there's no excuse. All right, 120 hours community service restitution, 40 of those hours will be waived if he completes, if he provides proof of the COVID vaccination. I'm not requiring you to do that, but if you have done it, 40 of those hours will be waived. There should be regular reporting in person or by Zoom. Field visits 2 times per month. You will be allowed to reside with Lisa Knoll for 90 days only. After 90 days, you need to get your own place. You're an adult. Your mom shouldn't be supporting you anymore. You understand?
Yes, ma'am.
So he's allowed to reside with his mom for 90 days. Then after that, he has to move. They want you to have cats 1 and 2. Here's my cats program for you. Don't take what doesn't belong to you. Stealing is not an occupation. This person's car that you took, it will never be the same. They're going to have to get a new one. You know why? Because you were in it without permission, and who knows how the car smells now that you've been in it, smoking marijuana and whatever else you did. Don't take what doesn't belong to you. Sometimes I have to give that lecture to people because they didn't learn it in kindergarten. And here's another side tip for you. If you are invited to someone's home, or if you are invited to a location, when anybody asks you to leave, you need to leave. And don't go to a location unless the person who owns that location or is on the lease at that location personally inviting you. You understand?
Yes, ma'am.
Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you don't have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, from here on out, everything that you do, we can go off the record, everything that you do, you need to ask yourself this question. This decision that I'm making, could it result in me possibly going into custody for 2 years? You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Yes, thank you. Always good seeing you.
Thank you.
You're welcome. Who's here on David Keonis?
Judge, I need to fix something with my mic real quick.
Okay, sure.
Good morning, Your Honor.
Good morning.
Afternoon.
No. All right. All right, the court is calling 2021 CR 9806, State of Texas versus David Keonis. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Gil Gonzalez.
And are you David Keonis?
Yes,
All right, you entered a plea to count 2 of guilty on August 9th. There was a TAP evaluation, and then there was a McMilf report. That's why this is late being heard. So have both, I'm sorry. And it was also recalled for the defense to provide the name of the case manager.
Right, yeah, we were unable to locate a case manager until he's placed on probation, or if the court does follow up on that. At this point, they do not want to assign a case manager until they know for sure whether or not he's going to have the avail of those services.
All right, and who did you speak to?
Your Honor, I don't have the name on me. It was one of the at the Center for Healthcare Services.
So are they saying that they will sign him a case manager?
Yes, if he's on probation, then they'll be willing to locate a case manager to help assist him while he's on probation to ensure he stays on his meds and follows through with any requirements he needs to help with his mental health issues.
Okay, and state, I know you're opposed.
Yes, Judge, and we argued last time. and
Yes.
I believe the court was inclined to grant his application, and we had no objection
Okay,
outside of our initial argument.
okay. All right, and the court will note for the record, the court did review the PSI report, and the court reviewed that again before his coming back, and the court will note that half of his skull is gone and he suffers from seizures, and now he has these mental health issues. But I will tell you that mental health issues does not mean that you get to go into society and do whatever you want to do. You understand? There are laws and you have to obey those laws. And I'm going to grant his application, but I'm not going to have him released until he has his case manager so that we can know what's going on.
Okay.
All right. And where will you be living when you're released?
With my father, we're both on a lease for an apartment.
Okay. All right. The court then will sentence you to 8 years deferred adjudication. Defendant to remain in custody. Until he's assigned a mental health case manager. And probation, I'm being told that the Center for Healthcare Services will give him a case manager. So that's to be through Center for Healthcare Services. And if he could be placed on the MIC caseload, there's to be no contact with Carlos Ochoa or David Gonzalez. There's to be regular reporting by Zoom or in person. I'm going to want field visits and probation. Let probation know that if they can coordinate their field visits with the case manager, so that maybe I'm going to ask for field visits 3 times a month. But if the case manager is going out, once a month, then probation will only have to do 2. And if they could coordinate with the case manager to see how he's doing. So field visits 3 times per month. There'll be regular UAs. And are you receiving SSI?
Yes.
All right, so there's to be proof of SSI or employment within 30 days. Of course, there's no employment as a home health care provider with minors. There's to be no unsupervised contact with minors. And what is your father's name?
David Quinones Senior.
All right, and defendant is to reside with David Quinones Senior. And defense, have you contacted his father to see if he's okay to live there?
Yes, Your Honor, and he has agreed that it's going to be a workable living situation. Workable living situation.
All right, probation, is there anything else that he needs?
No, Your Honor.
All right, is there anything else you need from the court in order to be successful?
Your Honor, the only thing I would ask the SSI, that'd be 30 days from when he's released, not 30
Yes.
days. Okay, make sure.
Mr. Quinones, is there anything else you need from the court?
No, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Oops, sorry. All right, good luck to you.
Thank you, Your Honor.
Thank you.
You're welcome.
So I have Your Honor, be excused.
Yes.
Thank you.
Who's here? Juan Garcia? All right. And probation, this is no application. Court is calling 2022 CR 8974, State of Texas versus Juan Garcia. Could I have the parties announced for the record for the state?
Michael Villarreal for the state.
Defense?
Joanne April.
And are you Mr. Garcia?
Yes, gentlemen.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Because I received everything that's on the sheet right there. I have no information that any of, anything else.
Right, the court will find that the state is in compliance with discovery. Mr. Garcia, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
No, Your Honor, state's proceeding on the lesser included offense of attempted violation of the sex offender right.
Any objection?
No objection.
All right, Mr. Garcia, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on the offense of attempted violation of sex offender registration as a state jail felony? Range of punishment is up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea bargain agreement, you're giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
My opinion wasn't his judge.
Mr. Garcia, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of attempted violation of sex offender registration as a state jail felony. They're asking that your punishment be assessed at 132 days in the Bexar County Jail under 12.44 of the Penal Code. There's a $0 fine, no applications, and of course, the court will give you any credit for any time served. And if the judgment is satisfied, the court will announce that the judgment is satisfied. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Then to the lesser included offense of attempted violation of sex offender registration, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. At this time, state offer states exhibit number 1, attachments.
No objection, Judge.
Mr. Garcia, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find you guilty of attempted violation sex offender registration. The court will sentence you to 132 days in the Bexar County Jail under 12.44 of the Penal Code. Give you credit for any time served. The court will show that the judgment is satisfied. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. if you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? All right, good luck to you. We can go off the record. I saw in the police report that you're homeless, but even though you're homeless, I'm sure your attorney has told you, you still must register. You understand? All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Excuse.
Yes. Who's here on Stephen Ward? Where's Stephen Ward? Come forward. All right, what is happening with this case?
Judge, we, last setting, we requested the medical records on the case. We got a return from them saying we need a HIPAA order.
Okay.
So we resubmitted that, I believe yesterday, because we just received in our mailboxes the letter yesterday from, I believe it was Methodist. And so we've re-requested those records.
All right, how long do you think it'll take for the records?
I think now that they're on notice, it should be within 30 days.
All right. Ms. Ferguson, can we call Mr. Ward for 30 days? All right, we'll see you on December 14th. And Ms. Ferguson will give you a reset form. Caroline, can you see what page Ward is on?
He's on the recall, the very top.
All right, thank you. Who's here on Trey Dion Johnson?
I am, Your Honor.
Okay. All right, where are we on this case?
I believe that Mr. Porter conferred with Michelle and then it's.
So, I'll ask.
Yes.
Yeah. We rejected the state's offer, Your Honor,
you can-
and we're requesting a jury trial.
Okay, you can, yes.
Oh, my bad.
All right.
And we're requesting a jury trial.
All right, your plea deadline date has expired. The court will only consider a plea bargain agreement in this case with good cause. Otherwise, you have to plea open to the court, okay? The court does have the acknowledgement of discovery. Ms. Ferguson, can we set this for a jury trial? It'll be in the new year, Mr. Porter.
Is it possible we could have it December 5th?
Okay, all right, December 5th.
Thank you, Judge.
All right, thank you. Who's here on Melissa Carlson?
That's mine, Judge.
All right, so what is happening with this case? And where's Miss Carlson?
She's in the back row, Judge. She's
Okay.
right there.
Yes.
I communicated with Daniel. He is looking at, the defense counsel brought up a couple of issues they wanted us to look into that I think we do need to look into, and Daniel's in the process of doing that. I believe he has not looked, he's bringing the officers in sometime soon, but we'd ask for another 30 days for us to continue looking into those issues.
All right, Ms. Ferguson, can I have a 30-day reset for discovery?
December 14th. Perfect. Thank you, Judge.
All right, thank you. Just get a reset form.
Okay.
Yes. Do you still have all the dogs in the house or no?
So we adopted 2 of 3.
I knew you were. They're so cute.
We have a lot of care.
All right, who's here on Joe Lopez?
Ready, Judge. So I was appointed today, Judge, just like court.
All right, we'll put that on the record to see if you need more time. All right, thank you. All right, are you good with the noise in the back behind you? Or do you need it moved? You sure? I can move them down to the, can you move them down to the other end?
At this point, I'll just yell, yell me to speak.
Oh, yeah.
Well, everybody's whispering today, and I thought maybe, do I have an ear infection or something? Because I can't hear.
I feel like that too. I don't know. Everybody's very soft spoken.
So again, I said, are they on the, have they moved to the other end?
Sure.
Yeah, if they're talking, they need to move to the other end. Oh, that's okay. All right, and probation, this is no application. Court is calling 2022 CR 8927B, State of Texas versus Joe Lopez. Could I have parties announced for the record for the state,
Brittany Sparks.
for the defense?
Kelly Piddle.
And are you Mr. Lopez? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
We did, Judge.
And the court will note for the record that defense counsel was appointed today through the will. Mr. Piddle, you do have, of course, as you know, 10 days to prepare for trial. Are you waiving that?
Yes, Judge, I discussed that with my client and he and I wish to waive that.
All right. And Mr. Lopez, do you wish to waive that?
Yes, ma'am.
I'm going to show you Mr. Lopez was entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Lopez, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand that you're charged with the offense of theft 2,500 to 30,000 as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 9 months in the state jail facility, and there are no applications. Did you understand that to be the plea?
Huh.
Defense is at the plea?
Yes.
State is at the plea.
Yes, Judge.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Okay.
State any evidence to support the defendant's plea.
Yes, Judge. States Exhibit 1 and all attachments.
No objection.
Showing you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and after reviewing the same, court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Certainly.
All right, Mr. Lopez, the court will follow your agreement. As previously stated, the court is finding you guilty. The court will sentence you to 9 months in the state jail facility, give you credit for any time served, showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Lopez, stealing should not be a profession. If you want something, you need to work for it. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
Thank you.
Thank you.
All right, court is calling 2022 CR 6616, State of Texas versus Sky Daniels. Is the attorney here for Sky Daniels? All right, come forward. That party is announced for the record for the state.
Brittany Sparks.
Elizabeth
Russell for Sky Daniels.
And are you Mr. Daniels? All right, why are you whispering?
Say yes, ma'am, I'll kind of have a call.
All right. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Daniels, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Daniels, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is charging you with the offense of retaliation? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Daniels, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived. I'm sorry, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the prison. There are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Judge.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
The motion's been filed but not been heard, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Judge. State's Exhibit 1, all attachments.
No objection.
Showing you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge, my client would like to make sure on the record that he's getting any credit for time that he's had in Bear County Jail.
All right. So, Mr. Daniels, your name is Sky Anthony Gonzalez Daniels. So I would like to know what racial slurs you were making towards Officer Silva.
I don't recall more. I was intoxicated.
Yeah. So you're making racial slurs at people and you're using intoxication as an excuse?
Maybe if I was, yes.
No, because here's my thing about intoxication. Intoxication doesn't make you behave any differently than you would have behaved if you were not intoxication. Intoxication just tends to
Well, yes,
relieve people of their inhibitions.
Yes, I'll make a racial slurs.
Yeah. So I don't understand why someone, your name is Sky Anthony Gonzalez Daniels, will be making racial slurs at Officer Silva.
He wasn't, Judge.
He just said he was.
That's not the, he wasn't.
No, that's what he said. He just told me he was.
Yeah.
So here's the thing, you need to start treating people with respect. People don't like when other people make racial slurs towards them. And here's the other thing, nobody is any better than anyone else. You understand?
Yes.
Showing you what's entitled trial court certification of defendants' rights to appeal. And I believe I did say I'm sentencing you to, oh, sorry. I'm sentencing you, I'm going to follow your agreement. I'm going to sentence you to 2 years in the prison, give you credit for any time served. Showing you what's entitled trial court certification of defendants' rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And treat people better next time. All right, good luck to you. Who's here on Jesus Gitron?
Burnham? You doing it? Martin?
Okay, just give me a second. All right. Oh, just have a seat. I'm going to come back to you next. Melissa Rich. All right, the court is calling 2015 CR 11876W, State of Texas versus Melissa Rich. Could I have parties announced for the record for the state?
Yes, Judge. Ryan Grimmer for the state of Texas.
Defense?
Attorney Alvarez, Little for Ms. Rich.
And are you Miss Rich? Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it? Are you the same Melissa Lynn Rich who was placed on deferred adjudication in 2015 CR 11876W on January 12th, 2016 for a period of 5 years for the offense of burglary of a habitation, no force? All right, state.
Yes, Judge. Off the state's motion to supplement violated condition number 5 in Bexar County, Texas.
Oh, I'm sorry, just 1 second. Did you receive a copy of the motion to supplement?
No. I have it, Judge. We've gone over.
All right, did you review it with your attorney? All right, you may proceed.
Violated condition number 5 in Bexar County, Texas. The defendant Melissa Lynn Rich did then and there fail to report to the supervision officer as directed for the months of August 2020 through June 2021 in violation of condition number 5.
How do you plead to that? True or not true?
Sure. We'd waive the remaining conditions. Judge.
Any objection?
No, Judge, sure.
Court will find violation of, well, I'm sorry, Miss Rich, did you understand by pleading true to violation of condition number 5? Court could find it true, find you guilty, not grant you community supervision, and sentence you up to 20 years in prison? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there an agreement?
There is, Judge. We'd ask that you follow our agreement that we enter an adjudication of guilt and revoke Ms. Rich's probation and sentence her to 2 years TDC.
Is that the agreement?
That is the agreement, Your Honor.
Are you asking the court to follow that agreement, Ms. Rich? Are you waiving your right to appeal? All right, the court will find you guilty, grant the motion, sentence you to 2 years in the prison, give you credit for any time served. I'm going to show you what's entitled trial court certification of defendants' rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you.
Thank you, Judge.
Yes,
Have a good day.
you too. Who's here on camera and cell? Are you okay? You need a break?
After this one, yes, my kid's school called, so I.
Oh, you want to go see?
Can I please?
Yes,
Real quick,
yes.
I'm sorry.
Oh, no problem. Just give us a moment. And according to our rules, when do we break? No, because we had that meeting. No, I think 12:45 is the last time for him to have that, and I think we break at 1:15.
Oh, okay.
Okay, all right, because I was like. All right, there are a couple that but it is nice not to have to come back after break. So, okay. That's the dream we hold on to. We don't have to come back after break. Well, you know what? I'm going to go to the bake shop for us. So that's what I'm going to go do.
I don't.
Okay, it's been super hot in the courtroom, and I just wonder if this is going to be one of the situations where the AC is fixed during the winter time, and it's going to be cold in the courtroom. Yeah. Yeah. Mr. Navy, depending on what the issue is, we may have to come back tomorrow. So I'm just seeing what the issue is. And Mr. Sell, if you all want to take a seat till oh, who is the attorney on Rangel? Oh, that's you. Okay, are you still conversing on that one? Well, it's just the last cases because we recess at 1:15.
Oh. Yeah, we're still.
Oh, well, no, you can continue. Norma, on this one, do you know where the attorney is?
Which one is that?
This is Trujillo. Is he in custody? Fernando Trujillo? And Deputy Laura, we decided that they said that we're supposed to stop at 1:15, right? Oh, it's 1:30. Oh, okay. All right, I just want to be sure.
These are the last of the inmates. All the inmates are here, Judge. There's
Okay.
no more downstairs or.
Do you need to go? No. You sure?
Yes.
Because I've already told everybody, we will break if we need to. Are you? No, because I mean, if it's an emergency.
No, Judge, I mean, I'll stay until you say.
Okay, all right. Because everyone is prepared. They know how I am about family. Everyone is prepared to break. All right, could I see Sal? Court is calling 2022 CR 5615, State of Texas versus Cameron Sell. Can I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Daniel Levy.
All right, and probation, this is an application. And are you Mr. Sell? Counsel, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Sell, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it? All right, I'm going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge. Proceeding on count one, waiving count two.
Any objection?
No, Judge.
Mr. Sell, I'm showing you what's entitled court's admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Okay. You're charged with aggravated assault against a public servant in count one. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison? Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor. I believe it does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe that, Your Honor.
Mr. Sale, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, state is proceeding on count one. There's $1,000 fine, affirmative finding of deadly weapon, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor. And just my understanding is that if he was to get deferred adjudication, the deadly weapon finding would be deferred as well. In order to receive the deferred adjudication.
I mean, there's still going to be a finding, an affirmative finding of a deadly weapon, but he'll get the deferred adjudication if I follow the plea.
Okay.
All right. All right. State, is that the plea?
Yes, Judge.
Defense?
Yes, Your Honor.
And did you understand that to be the plea? All right. And I see there's a case number that's been marked through. Has that case already been taken care of?
It will be judged, but it's not part of the plea agreement.
Okay. All right. Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor. Well, there was a motion to set aside the indictment, but just one, I guess.
All right. And are you waiving that motion?
Yes, Judge.
Okay. Next, I'm showing you outside the agreement. The state is requesting that your deferred adjudication be for a term of 10 years. There'll be a TAP evaluation, 200 hours of community service restitution, the MRT, and defensive driving. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense is charged in count one. How do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Judge. State out for states exhibit one and its attachments.
No objection.
Mr. Sale, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding the guilt if you apply for deferred adjudication. Are you proceeding with sentencing?
We're fine proceeding with sentencing, Judge.
Anything you wish to say on behalf of your client?
Judge, I'd just like to offer defendants exhibits 1 through 6, and I've showed them to the state.
Any objections?
No, Your Honor. And Judge, what those are, number 1 is an apology letter to the police officers. Exhibits 2 through 5 are various psychiatric, psychological, and counseling records indicating some of his various mental health issues that he's been dealing with in his young adult life. He's been diagnosed with anxiety, depression, ADD, ADHD, opposition and defiance disorder. He hasn't been diagnosed with autism, but it hasn't been ruled out. And some of the psychiatrists believe that he needs further testing to see if that's something that he was dealing with, Judge. He's a young man, I believe you're 19, 18. He's had no violations on his pretrial monitor, Judge. He's never been arrested before he finished his high school diploma. That's defendant's exhibit 6 that you have. And we would ask that you follow the plea bargain agreement.
All right, so are you working? What are you doing with your life right now?
At the moment, I kind of made it hard on myself with this. I kind of told myself, hey, since you got this, it's kind of hard to get a job. So while being on this, I really haven't put too much time in trying to do that because I've been so stressed and like talking myself down, I guess.
You need to get a job.
Yes, so I actually have a buddy who just got offered a job recently, and he's going to see if they can get me up in there as well.
Doing what?
Just working at a gas station now.
Okay. All right. I don't understand the request for defensive driving.
Because of the facts of the district.
But I'm sort of like, if somebody's.
I think this may resolve the issue, Judge. He did complete a defensive driving course recently. And so I would ask that he just get credit for that if he shows probation, the certificate.
All right. 10 years deferred adjudication, defensive driving. There's $1,000 fine that will be probated. Do you have any children? Right. Anger management. No, I mean, I'm assigning anger management courses. And that's based upon the exhibits that's been presented to the court. There's an affirmative finding of a deadly weapon. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. The remaining hours will be waived if you enroll in some higher level of education. If it's college, I will tell you, are required to be full-time. So if you plan on enrolling to college, the court will not waive the remaining of the community service hours unless you are taking at least 9 hours per semester, or if you are in a trade school and obtain a certificate. There's to be regular reporting, regular UAs. If you're drug tested today, what are the results going to be? What are you going to be positive for? And what else? All right. Marijuana is not allowed. You understand? We're going to do the testing for levels. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. They want you to do the MRT. The MRT course is telling you that you need to consider others in your action. It's something that people should learn in kindergarten or preschool. Be nice to everybody, treat others as you would want to be treated, but you're going to take the course. I'm going to want field visits 2 times per month. Who do you live with? All right.
And father.
So here's the thing. You're either going to have a job while you live with your mom, or either you're going to be in school. I don't allow people who are adults to live at home unless they're working or either they're in school at your age. You understand? All right, probation, is there anything else?
No, Your Honor.
Is there anything else you need from the court in order to be successful? Show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you.
Thank you, Judge.
Oh, I forgot to get the top portion. Oh, and Marcus? Oh, I see there's 2. There's already 1 that I've signed. Thank you. So are you ready on Rangel? Okay, what is happening with Mr. Rangel?
That was, we stated, operative. Offer, that's the word I'm looking for today. We're respectfully requesting only time to think about that.
Okay.
And we would request a shorter period.
Okay, so you don't want to, you want to come back before December?
I think I made the offer open for 30 days, so as long as it's roundabout there, that.
All right, so it's December 16th, okay?
That works.
All right, Mr. Rangel, we're going to come back on December 16th. December 16th will be your plea deadline date. The court will not accept any pleas after that date without good cause. You understand? All right, we'll see you then. Yes. Okay, thank you. All right, who are all of these people in the box? All right, Brian Parker. Jose Romo. Oh, no, he approached on that one. I'm going to take care of that.
Okay, Jose Romo is the attorney's stick on that.
Okay. Okay, Jose Romo, we'll recall that then on the 16th. Or did Norma give you another date? All right, so on Romo, we'll recall for December 16th, and if they want it sooner, they can let me know. All right, and who is here on Victoria Cifuentes? Yes, what is happening with that case? Okay, all right, thank you. Okay. Okay, and this shows that this has been reset for November 17th. I don't know why it made the docket. And then they say they're playing on that one. And could I see Mr. Villarreal and Martin Guerra? Oh, in the back, please.
It's not about anybody with this big thing.
You're welcome. So that's what I want to do at the break. We have Luis Puente on the box.
Judge, do you happen to have exhibit 6 up there? He said that it was exhibits 1 through 6. I only have 1 through 5.
Okay, I'll check and see if. I'll check with Caroline to see if she has. Because number 6 was the high school diploma.
Oh,
The high school.
I didn't even look in the record. I just remember it was.
Oh, yeah, no, it's a high school certificate.
Luis Puente.
Let me see what page he's on, but that one may be fine. Oh, Luis Puente, he's gonna go back because I don't know what his attorney is. And we'll give him on another day. Luis Puente, we don't know where your attorney is. All right, so what we're gonna do is we're gonna bring you back. We're gonna recall you tomorrow. And if he's not present, we'll appoint you someone else.
Rios Nelda.
Okay. What page is that on? Let's see. Okay, Rios.
That's on the first page of the report.
All right, I'm just gonna roll on the violation report, but she can go back. Miss Nelda? Rios Nelda, your attorney's not here, so we're gonna send you back and we'll recall you on another date.
Melissa Rich.
That's been done.
Richie Christopher.
That was done.
That was for a PR.
Oh, yes, that's completed. He got bonds.
That one is withdrawn, so I'll take everybody else.
All right,
And then
thank
the
you.
appointment is gonna be too, right?
Yes. All right, and this one's done. Oh, and she said she's missing exhibit number 6 on the one with Nathaniel Navy. Yeah, and that was a high school certificate.
Richie Christopher.
Thank
Melissa
you.
Rich.
Thank you.
Nelda Rios, and Luis Fuentes.
So I said that one's gonna be employee. I don't see the problem, Louis. Right there.
Nobody's having to. Nobody. Nobody.
Louis Point.
Oh, thanks. Thank you.
Because on that one, just let Norma know that we're recalling that for the 17th.
Okay.
But I needed to write on the docket sheet why we're recalling it. All right, thank you. We just have a few more cases. So we ended up having a meeting and we decided that we would break at 1:30.
Okay.
So that's why I was looking at the clock. See, I'm still remembering the Festivus meeting. Okay.
It was one. It's one.
12:45, everyone's supposed to like, go that.
Okay, see, let me just tell you who told me 1:30. Deputy Laura told me 1:30 and Caroline told me 1:30. Because I was like, shouldn't we be, shouldn't this be done? And then they're like, oh no, it's 1:30. I'm like, okay. And my mind is a steel trap, but it's not a steel trap today because my mom had her doctor's appointment. So my mind was focused on that. So. Hello.
right, thank you. All right, court is going to call 2022 CR 7092, State of Texas versus Victoria Cifuentes. Can I have parties announced for the record for the state?
Three charges.
Defense?
Carmen Gay.
And are you Ms. Cifuentes?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Ms. Cifuentes, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Did you sign it? Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
No, Judge, we're proceeding on the lesser included Class A misdemeanor assault bodily injury.
Any objection?
No objection.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of assault as a Class A misdemeanor? The range of punishment is up to $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counselor, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Fuentes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir.
According to the plea bargain agreement, state is proceeding on the lesser included offense of a Class A misdemeanor assault bodily injury. They're asking that your punishment be assessed at 365 days in the Bexar County Jail. State recommends community supervision. They're taking consideration County Court Cause number 6911055. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes.
Next, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, no such motions.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 1 year. There'll be a TAP evaluation and 120 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense of assault bodily injury as a Class A misdemeanor, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge. States Exhibit 1 and all attachments. No objection.
Ms. Cifuentes, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're asking that the court follow the recommendations set forth and she's been incarcerated. She tried to get her COVID shot. She's on a list there at the jail, but she didn't receive one. Just want the court to know that.
Okay. So you're intoxicated and things just go south from there.
Yes, ma'am.
So why did you get intoxicated? What was going on this night?
I just went out for drinks with a couple friends and I didn't
I was being reckless and I was over drinking.
All right, do you have any children?
I have one child,
Age? I'm sorry,
5 years old,
and where was your 5-year-old when you were out drinking?
with his father.
Do you have employment?
I'm currently unemployed.
When's the last time you had employment?
Right before I got arrested. In
Doing what?
October the first week of October.
Doing what?
I was a security guard with Cerberus Security.
Not anymore. And do you live by yourself?
I am currently homeless.
So where are you gonna live if you're released?
I plan to go into a halfway home or a shelter that could give me resources and get me back on my feet.
And where is your child gonna be staying?
For the meantime with his father, so he can, be enrolled in school and everything and have that stability.
Is there any drug issues with you?
No,
I'm sorry,
no, ma'am.
have you ever tried drugs? And what would that be?
Marijuana.
And what else?
That is all.
All right, because now's the time to tell the truth, because I'm trying to set your conditions so you can be successful. So if something happens and it's because you didn't tell me the truth, that's 100% on you. You understand? So is there anything else that I need to know about?
No.
All right, the court will sentence you to 365 days in the Bexar County Jail, suspended and probated for 1 year. Taking consideration County Court Cause number 691055. 120 hours of community service restitution. 40 of those hours will be waived if you provide the COVID vaccination. The court is not requiring you to get that, but if you do, 40 of those hours will be waived. Parenting classes with Triple T. Once you complete parenting classes, the remaining of those hours will be waived. There's to be regular reporting by Zoom or in person. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Anger management course. There's going to be 30 sober meetings in 30 days. And we'll do outpatient treatment with probation. And do you believe your son's father is a good father?
Yes, ma'am.
Are there any issues with him?
No, ma'am.
Any violence?
No, ma'am.
And he's married and has other children. So
Okay.
the child's in a stable place.
All right. Probation, is there anything else she needs?
What, outpatient treatment is like, supported or intensive?
Supported,
Can we get a tap with that?
yes.
She mentioned it, nothing about field visits because
We'll do field visits 1 time per month. And just, that's until she gets a stable residence.
okay, and then you said, you mentioned UAs.
Oh, thank you. Yeah, regular UAs.
And regular virtual or in person, correct?
Yes.
That's all I know.
All right. Is there anything else you need from the court in order to be successful?
No.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. We can go off the record. You have a 5-year-old. You can't go out and be a crazy college kid, which I don't think college kids should be doing it either, but you cannot and should not be drinking to excess. Because now your son has been without his mom because you've been in jail because of your actions. Okay? All right, good luck to you.
Thank you
Your
so
Honor,
much.
on one thing on that, want a top evaluation in custody or outside of custody?
We can do it out of custody. If you miss that TAP evaluation appointment, you're going to find yourself on a motion to revoke back in custody. You understand?
Yes, ma'am.
All right, thank you. All right, who are the other people in this courtroom? Oh, Cornelius, please come in. And who are these 3 people who are in the court?
Sure. Those are my clients. My clients' parents in the very back row.
Okay, who is this? Oh, and who is this person over here? And the person in the shirt, he says he's with you.
I think he's with the.
Oh, he's with, okay, all right, thank you.
Or with the lawyer.
Okay. All right, so I'm sorry, what is your name, sir? All right, Marco, we're gonna close, we're about to close court, so if you could wait outside and the attorney will meet you outside, okay? Thank you. And then we can go forth. Are you ready to proceed?
Yes, ma'am.
Are you okay with proceeding now?
Yes.
Okay. All right, the court is going to call 2020 CR 3666 State of Texas versus Jesus Gitron. And Mr. Cox, before you leave, if you can wait, there's a matter that we need to take up with you. All right, could I have parties announced for the record for the state,
Michael Miller of the state.
for the defense?
Martin Guerra, attorney for Edward Petron.
And are you Mr. Gitron? All right, I'm going to show you what's entitled Motion to enter adjudication of guilty and revoke community supervision. First Amendment motion to enter adjudication of guilty and revoke community supervision. Second Amendment motion to enter adjudication of guilty and revoke community supervision. State's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. And state's second motion to supplement pending motion to enter adjudication of guilt and revoke probation. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
Are you the same Jesus E. Gitron III, who was placed on deferred adjudication in 2020 CR 3666 for the offense of indecency of a child by exposure on May 7, 2021 for a period of 5 years and extended for a total of 1 year? Is that you?
Yes, Your Honor.
Right, state?
Violated condition number 1, on or about the 12th day of March 2022 in Bexar County, Texas, the defendant, Jesus E. Gitron III, committed the offense of violation of bond or protective order in violation of condition number 1.
How do you plead to that? True or not true?
The state would waive and abandon the remaining allegations.
Any objections to the state's waivers?
No objection.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there an agreement?
Yes, Your Honor. The agreement to grant the state's motion, enter adjudication of guilt, and assess punishment of 2 years confinement in the Texas Department of Criminal Justice Institutional Provision. There would obviously be mandatory chapter 62 registration. The state is going to take into consideration cause number CM 96740, which is the case that the defendant just pled true to on the MTR.
96740.
96740, yes.
All right. Is that the agreement?
That is, Your Honor.
Mr. Gitron, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will follow your agreement. The court is finding violation of condition number 1 true. The court will find you guilty, revoke you, sentence you to 2 years in the prison, give you credit for any time served. There's to be chapter 62 registration, taking consideration CM 96740. Is there anything else from either side with regards to sentencing? Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. We can go off the record. You're gonna have to do better. And when you get out, you're gonna have to register. You understand? All right, good luck to you. You're welcome.
Thank you, Your Honor.
You're welcome. Oh, just 1 second. So we'll be back tomorrow at 9.